The House will come to order. Prayer by the chaplain.
Good morning. Let us pray. Dear Holy Father, we thank you for this beautiful, glorious Saturday in May. We ask blessings upon our work tonight and today. Some of us might be a little tired, worn out, a little grumpy from a long week and a long weekend. But we ask your blessings upon all of us today, that we may be wise in our words, kind in our actions, and thankful for all that you've done for our country and for our families. Bless our work today, that we may glorify you in everything we do, everything we say, and everything we think. Be with our families who are home. Keep them safe from all harm and evil, and bless them. Bless all of our staff and all those who work in this beautiful building, that they too may do your work as we end session. We glorify you and thank you for all the blessings you bestow upon us, particularly our health, happiness, and our freedom and liberty. And a little Irish blessing as I close. May God give you all, for every storm, a rainbow, for every tear, a smile, for every care, a promise, and a blessing in each trial. For every problem life sends, a faithful friend to share. For every sign, a sweet song, and an answer for each prayer. Amen.
The chaplain for today is Joe McDonald, representative for District 29A from Delano, Minnesota. Pledge of Allegiance. Please remain standing and recite the Pledge of Allegiance to the flag of the United States of America.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good job.
The clerk will take the roll.
African American Family Preservation Act is the only thing I know.
The chief clerk will call the names of the members voting remotely.
Carol present.
Carol present.
The clerk will close the roll. A quorum is present. The clerk will read the journal of the preceding day.
Journal of the House, 93rd session, 2024, 117th day, St. Paul, Minnesota, Friday, May 17th, 2024.
If there is no objection, further reading of the journal will be dispensed with, and the journal will be approved as corrected by the chief clerk. Hearing no objection, the journal is approved as corrected by the chief clerk. Introduction and first reading of House bills.
The following House files.
The following House files have been offered for introduction today. The chief clerk will report the House files and give them their first reading.
Introduction and first reading of House files 5479 through 5480.
First reading, House File 5479 through 5480. Messages from the Senate.
Message from the Senate. Madam Speaker, I hereby announce that the Senate has concurred in and adopted the report of the Conference Committee on House File Number 716, an act relating to human services, establishing the Minnesota African American Preservation and Child Welfare Act. The message is signed Thomas S. Bodern, Secretary of the Senate. Conference Committee report on Senate File Number 716. The report is addressed to the Honorable Bobby Joe Champion, President of the Senate, and the Honorable Melissa Hortman, Speaker of the House. We, the undersigned conferees for Senate File Number 716, report that we've agreed upon the items in dispute and recommend as follows. The report is signed by 3 of the 3 members on the part of the Senate and 3 of the 3 members on the part of the House. Agbaje moves that the report of the Conference Committee on Senate File Number 716 be adopted and that the bill be repassed as amended by the Conference Committee.
I recognize the author, Representative Agbaje, who will explain the report.
Thank you, Madam Speaker. Yes, we were able to have our conference committee yesterday and accepted some pretty quick changes. The Senate actually mostly accepted the majority of the House provisions that laid out the safety plans, support for children with disabilities, and when and how parental rights can be terminated if necessary. We also took the Senate funding to allow DHS to do its work, and we also included a reference to relative placement in the section that discusses non-custodial parent notification to ensure that relatives would be the ones that would be called should a child be involved in the CPS system. Most importantly, we also updated the timeline. The program will now start in both Hennepin and Ramsey on January 1, 2025, and then it will go statewide on January 1, 2027. In between those 2 years, there will be an interim report due on January 1, 2026 to describe to other counties that are interested in this program how to stand up a program in the first year. as well as any recommendations for any policy or statutory changes that the 2026 legislature could take up. And then the final report would be due in September of 26, giving time to review before going statewide in January 1 of 2027. I just want to again express my thank yous to the Chamber, both the House and the Senate, for moving forward on this really important bill to ensure that more families can stay together and that they also get the type of care and fairness that they deserve out of our government system. So with that, I urge a green vote on the report. Thank you.
Discussion on the conference committee report. There being no further discussion, all those in favor of the motion to adopt the conference committee report on Senate File 716, please say yay. Aye. Those opposed say nay. The motion prevails. The clerk will give the bill its third reading as amended by conference.
Third reading, Senate File number 716, as amended by conference.
Third reading. Any further discussion? Representative Hudson.
Thank you, Madam Speaker. The story of this bill goes back way beyond I ever got here. And while it's an honor to be here as it passes the finish line, I think it's worth noting that this is not the completion of a project. This is step one in addressing issues that in particular affect the Black community, also affect other groups that are disproportionately represented in the CPS system. But I hear these stories, I've heard these stories from the moment I got involved in this process, from all sorts of communities about their engagement with CPS and lack of fair treatment. And so I think we're going to discover, I hope we discover through this process, ways to be able to provide for the entire state, for the broader community, and to make the CPS system more respectful of the fact that taking somebody's child is a level of government intervention that should be right up there alongside incarceration. You should be able to prove that circumstances are such that there simply is no other choice, and this bill goes a long way towards accomplishing that. I also want to very briefly just note that this bill acknowledges that there are communities that have been underserved, and part of our kind of global approach to other issues impact that. Education in particular comes to mind. We've noted it again and again that about half of our kids can't read at grade level. And that's not just a talking point, that's a reality that affects the lives of countless people, and no doubt disproportionately the community that we're dealing with here and other communities that are disproportionately impacted by the CPS system. So if we can take this spirit of accomplishment and roll it into our consideration of those more global issues, the state will benefit. Thank you, Madam Speaker.
Further discussion. I recognize the member from Chisago, Representative New Brindley.
Thank you, Madam Speaker. I just want to make a couple of brief comments. I actually thank you, Representative Hudson, for your comments, because I'm sensitive to that. I stayed off the board on this the other day because, frankly, I hadn't had enough time with it. I've heard this in the past. This is a wildly different version of the bill that we've seen in the past. It's a much, much better version in many ways, and I appreciate that. Today, however, I'll be voting no on this, and I want to let folks know why. And it's very specific language, and it's frankly the disproportionately represented child language, the definition, including low socioeconomic status. Now, I understand the pitfalls. I understand that there are situations where a lack of resources can be construed as neglect or other things. I've been very clear, though, in this body, and I will continue to be very clear. My highest moral imperative is protecting children. And my belief is that this language makes this far too broad and that actually the vast majority of families involved in child welfare in this state are from low socioeconomic status families. And we are making it more difficult to protect children in the vast majority of cases involving child protection. And I don't think that's the direction we want to go. And I hope I'm wrong, because there are actually a lot of good provisions in this language. There's a lot of stuff I like. So I hope I'm wrong. But this is way too complex of an issue to take a chance. And so my vote will always, hands down, go to protecting kids. And I think this language, this overly broad language, puts kids at risk. We just dealt last summer with a series of articles on Minnesota's child welfare system from the Star Tribune. They did a series of articles titled "In Harm's Way," talking about the revolving door of kids coming out of families and entering a revolving door, and how kids have been hurt by that. And my concern is that this language will exacerbate that problem. And again, not just for one small group of kids in this system, but by including the disproportionately represented child definition of low-income socioeconomic status, that is almost 90% of families involved in child welfare. If you look at the data, it's almost 90%. That's the vast majority of families involved in child protection. That bar just got higher. That bar just got harder to protect kids in those cases. So I'm going to be a no vote today.
Any further discussion? I recognize the author of the report, Representative Agbaje.
Thank you, Madam Speaker. Thank you, members. I will just say that this bill has gone through a number of iterations and a number of language changes. When we first started, we really actually had a really narrow focus. We really wanted to focus this on the disparities that we were seeing in the Black community. But we knew, because of the current makeup of our Supreme Court and our constitutional jurisprudence, we had to broaden. We had to ensure that in order to protect Black children, we needed to be able to say that we were also protecting other kids as well. And so that's part of the reason why you see that language that you do. But at the end of the day, I do think that this is a good bill. This is a good bill. It's a stepping stone. It's an initiation. It's the beginning of a process of repair and harm that has been done to families, particularly families of color, that in the United States oftentimes get their children taken away without questions asked. So I hope that the members today will vote green in order for us to begin this process of healing and reconciliation in the state of Minnesota. So thank you.
There being no further discussion, the clerk will take the roll. Members, please vote. The chief clerk will call the names of the members voting remotely.
Carol.
Carol, aye.
Carol, aye. That's it, right?
The clerk will close the roll. There being 117 yeas and 5 nays, the bill is repassed as amended by conference and its title agreed to. We're going to revert to the reports of standing committees and divisions. A copy of this order of business is on your desk and online. If there is no objection, the reports will be adopted. Hearing no objections, the reports are adopted. Second reading of bills of Senate files.
Second reading, Senate File Number 4027.
Second reading. Conference committee reports on House files.
Conference Committee report on House File Number 4757, an act relating to cannabis. The report is addressed to the Honorable Melissa Hortman, Speaker of the House, the Honorable Bobby Joe Champion, President of the Senate. We, the undersigned conferees for House File Number 4757, report that we've agreed upon the items in dispute and recommend it as follows. The report is signed by 4 of the 5 members on the part of the House and 5 of the 5 members on the part of the Senate. Stephenson moves that the report of the Conference Committee on House File Number 4757 be adopted and that the bill be repassed as amended by the Conference Committee.
I recognize the author, Representative Stephenson, who will explain the report.
Thank you, Madam Speaker and members. This is the Conference Committee report that includes the Cannabis Policy Bill, the Commerce Budget Bill, and the Cannabis Budget Bill. We had a great Conference Committee with participation from both sides of the aisle here and good discussions. The House provisions in the Commerce Finance Bill were all included. Same with the cannabis provisions. Also included was Representative Elkin's outstanding work on data privacy. That's going to be nation leading. We did accept 2 provisions from the Senate in the commerce world. One relates to the 340B prescription drug program. The other relates to the issues that are around copper wire thefts here in St. Paul and other areas. In the cannabis space, the bill includes the provisions that left the House floor. There was some refinement in conference, but nothing brand new. So it was a very good conference committee, and I urge members to adopt the report.
I recognize the member from Hennepin, Representative Elkins.
Thank you, Madam Speaker. Members, while browsing the internet, you have probably encountered statements like, if you're a resident of California, Colorado, or Virginia, you may have these additional privacy rights. With the passage of this bill, Minnesota is poised to join the ranks of states whose residents enjoy these rights. Like the laws that have been enacted in 15 other states so far, the Minnesota Consumer Data Privacy Act, included within this bill, will grant Minnesotans the right to prevent their data from being sold to data brokers or used to target advertising at them. In the case of sensitive personal data, including their location or biometric data, companies would have to secure your permission before they use it in this manner. As a consumer, you will have the right to know what data a company has about you, to obtain a copy of that data, to have errors corrected, and to have your data deleted upon request. You will be able to opt out of having your data used to profile or score you using automated decision processes, and if your data is used to profile you in a way that affects your access to jobs, housing, or insurance, you will have the right to question the data and the automated decision-making process used to make the decision, and will have the profiling model rerun with the corrected data. You would be entitled to a plain English explanation of why the decision was made the way it was and what you could do differently in the future to achieve a better result. Companies would be required to publish a plain English description of their privacy policies to protect the privacy of the consumer data in their possession, to keep track of the data that they have about you so that you could exercise the previous rights, to limit the collection of consumer data to that which is necessary to provide goods or services to you, to retain it for no longer than necessary to serve those purposes, to name the person responsible for administrating these responsibilities, and to conduct periodic assessments enforcements of their data privacy policies. They would be prohibited from using consumer data in a discriminatory manner, and they would be prohibited from attempting to identify the subjects of anonymous consumer data. Some of these protections are not found in other state laws. Minnesotans are going to enjoy the strongest data privacy protections of any state in the country. And finally, I want to thank my drafter, Nathan Hopkins, and House Research, who has been my partner for 5 years of this incredibly complicated endeavor and has done just an amazing job in helping me keep this bill organized and get it into the condition it's in right now. So please vote green on this concurrence.
Discussion to the Conference Committee report. I recognize the member from Anoka, Representative West.
Thank you, Madam Speaker. And this conference report could be, I would argue, much, much better. I'm not going to rehash everything I said in the conference committee. I appreciate the chair including me in some of these conversations to try and make this a better bill, particularly on the cannabis market decisions. I also got the courtesy of a 9:30 p.m. phone call to tell me what else was being dropped into the bill, which, you know, I do appreciate, but that is no way to have a conference committee function. I feel like all these bills were already in conference. They should have moved in their conference committees where they belonged. Being dropped on from on high, especially if it's brand new language, is just, that's how you run into problems. I mean, a lot of your bills are having problems. Cannabis is one of them. That's how you get problems, when you do things without following the proper process and procedure and proper vetting. In particular, when these things are dropped in, it's, well, what are they trying to avoid? What are they trying to skip? Now, I'm not questioning motives, but for example, the 340B provisions, which myself, I have been desperately since 9:30 p.m. after I got that phone call trying to learn about that program. So I myself do not have a strong opinion about it yet. I can see the pros and cons, but I'm fairly certain it did not go through the Health Committee. And you know, something that deals with hospitals and pharmacies and the like probably should be vetted in the Health Committee. Now, I invite, I'm not going to ask to yield because I don't try and waste too much time, but I invite Chair Liebling to correct me if I'm wrong, but I believe that is the case. So members, because of the way that was handled in particular, on the final motion, I would definitely recommend voting against it because a lot of things in the cannabis provisions were not improvements, but I appreciate the chair including some of my hemp provisions in particular. But with that being said, Madam Chair, I would move that we refuse to adopt the conference report.
Representative West moves to refuse to adopt. Are there 15 hands? There will be a roll call. Discussion to the West motion to refuse to adopt the report of the conference committee. I recognize the member from, I should know this by now, Morrison, Representative Schultz.
Thank you, Madam Speaker. Representative West is right. We have a lot of new language in this bill. I understand a lot of it was being worked on behind the scenes, but in the era of transparency, I'd like to ask if Representative Hollins would yield.
Representative Hollins will yield. Representative Schultz.
Thank you, Madam Speaker. Representative Hollins would, could you walk us through a little bit of the changes to the copper, the sale of copper and licensing standards found within this bill?
Representative Hollins.
Thank you, Madam Speaker. Thank you, Representative Schultz. Absolutely. So as most of you know, this was heard in the House in all the committees and was, we were prepared to move forward with this as a standalone bill, but it was looped into some commerce work that was happening over in the Senate, and so it was included in this bill. The changes in particular that have happened more recently was adding 2 times a year for individuals to bring copper in without any sort of licensure. They can do up to $25 worth of copper, which is about 7 to 8 pounds of copper at the going rate currently. And we also made sure that well drillers, electricians, contractors were deemed to hold a license, and that auctioneers were covered under the law. So those are the main changes that were made going forward.
Representative Schultz.
Thank you, Madam Speaker. This provision, to me, I think there needs to be a lot more work done on this. I don't think that this is ready for prime time for us for a few specific reasons. She mentioned that there's a few different interests and entities who might have a little bit of certainty now based upon the agreements that have been made in the conference committee. But what I'll make mention of, Madam Speaker, is that when we are taking a look at this language around the buying and selling of copper and the recycling of copper in our state, this is really important. This happens all the time, everywhere, from construction sites to farm sites to every corner of the state. This sort of thing happens, and it's recycling. It's positive. It's good. We need to do it. There's a lot of needs for copper in our world today. And when I'm looking at this, let's just start from the very beginning. There are people who are stealing copper wire and other copper products all over the state. And at the same time, what we see is that the crime of theft in our state and in certain specific municipalities, it's not properly making its way through the judicial system, and the criminals aren't being held accountable. And what we have here with this underlying bill is a bill that is punitive towards the people who are trying to recycle and to do it lawfully. Because of this bill, the lawful recyclers of this state will have to pay $250 a year to be licensed to sell copper, to buy and sell copper. Recyclers, $250, making Minnesota more expensive, a lot more expensive for people who are just trying to do the right thing and to ensure that we aren't wasting in our world today. In addition to one of the points that Representative Hollins made just a moment ago, I'd just like us to all talk about the practicality of having a specific day every month dedicated for only that month for someone who's not licensed to deliver only up to $25 worth of scrap. What that means, Madam Speaker, is that if you're not licensed and you want to recycle a little bit of scrap and bring it to a scrap metal dealer, what that means is that you potentially are going to spend more money hauling the scrap to the scrap yard than the amount that you're able to bring there. You're going to spend more money in gas, especially if you're bringing it by truck to a given location, a given scrap dealer. You're going to spend more money. In essence, this language around non-licensed scrap dealers, it's not going to hit anybody at all. It's unworkable, wholly, which means that it's just going to be punitive towards the people who are doing good work. Meaning every single year, they're going to have an additional license, an additional $250 fee to pay to do recycling in our state. All the while, the people who have actually stolen copper in our state aren't held accountable. They're giving things, there's a recent news story where people who've stolen copper wire in St. Paul were just put on probation. They weren't actually held accountable for their actions. So the tactic that we're taking with this language here isn't going to solve the problem. And it's not going to put wire back in the light posts all across St. Paul. It's not going to do that. So I think that this language needs a lot more work, which is why we should support Representative West in his motion to refuse to adopt.
Further discussion on the West motion. A member from Anoka, Representative Scott.
Thank you, Madam Speaker. Would Representative Hollins yield to a question?
She will yield. Representative Scott.
Thank you. Representative Hollins, I know that this bill didn't come to Judiciary, and there are probably reasons for that. I think more so reason for what's missing in this. But I know the database is being set up in each of these entities that are scrap metal dealers and all the things. But the language says that law enforcement can have access to that database at any time. And that's, in my mind, I guess the question I would have is that subject to a warrant or not subject to a warrant?
Representative Hollins.
Thank you, Madam Speaker. Thank you, Representative Scott. I couldn't tell you exactly. My understanding is that the databases are already set up, and this is going to be integrated into databases that already exist within the Department of Commerce. So however that functions currently with the warrant process is how this would function.
Representative Scott.
Thank you, Madam Speaker, and thanks for that answer, Representative Hollins. I know this database was set up, I think, last year or the year before when we were dealing with the catalytic converter issue, and it just kind of came to my attention that current law says that law enforcement can look at it anytime, and there's no language that says a warrant is required. And so that gives me a little bit of pause with that, but I understand it's already current law. I just wanted to get that on the record as being, maybe flag that. So thank you, Madam Speaker.
I recognize the member from Chisago, Representative New Brindley.
Thank you, Madam Speaker. Would Representative Stephenson yield for a question?
Will yield. Representative New Brindley.
Thank you, Madam Speaker. I'm just hoping that you can just shed some light. This was, I mean, we do some crazy things procedurally around here, but taking an entire commerce omnibus bill, plucking it out of its conference, taking that in its entirety, and plopping it into a different conference report. Can you just tell us why you did that?
Representative Stephenson.
Thank you, Madam Speaker. Thank you, Representative New Brindley. It is something that happens here every year, as I know you are well aware. In fact, it happened earlier this week with the Children and Families budget moving from one conference committee to another, and that's often done just to facilitate a process. In this case, there were ongoing discussions in both the ag and the energy space, but the commerce budget was wrapped and the cannabis budget was wrapped, and we were ready to move forward. And so in the interest of expediency, we made the decision to move forward to allow the ag and energy folks to continue their conversations, and we were able to move the commerce provision forward. I also do want to mention that both of the provisions that were not in the underlying House bill, the 340B provision and the copper provision, passed the Senate floor. Both went through the complete committee process in the Senate. Both actually went through a committee process in the House. 340B was heard in the Commerce Committee. It was not heard in the Health Committee, but it was heard in the Commerce Committee. In the Senate, it was heard in Commerce and Health and Rules. And the copper provision was heard in the appropriate committees in the Senate, also did receive a committee hearing in the Commerce Committee in the House. So these provisions did have a very public process that occurred over a period of months. I see the first hearing on the 340B provision was in March. So there was a lot of opportunity for the public to weigh in on both of these provisions throughout the process.
Representative New Brindley.
Thank you, Madam Speaker. And thank you for your honesty, Representative Stephenson. This was done for expediency. And in doing things for expediency, we removed transparency. Because there were a lot of us who were actually watching the Commerce Ag Energy Bill. But frankly, I don't care about cannabis. I wasn't watching the cannabis bill, and I didn't find out until after it wrapped that those provisions were posted at 11 o'clock the night before. The commerce provisions were posted at 11 o'clock the night before to be dropped in the next morning. I literally did not know it happened until after it happened. So you say we do this for expediency all the time? I mean, I just looked at the list, the conference committee list, and it looks like the energy, ag, whatever bill, it looks like that's wrapped or ready to wrap as well. And so we just completely eliminated all transparency just to do something fast, just for expediency's sake. Well, that's not an honest way to do business. That's not a transparent way to do business. And it is not a way to do business that allows Minnesotans to know what's going on. We are the elected representatives trying to look out for the interests of our constituents. And when things like this are done, 11 o'clock at night, 11 o'clock at night this was done. In a bill that frankly I wasn't paying attention to. Pulled from the bill that I was paying attention to. And just like that, it's all done. And I wish Representative West, he was scrambling. He doesn't serve on the Commerce Committee. And he's the one Republican serving on this committee, and he is scrambling to try to figure out what this even does. He's never heard these provisions before. It was not transparent to the public. Frankly, it was not transparent. It was not fair to Representative West, who has never heard this stuff, and it was all of a sudden in a position where he's the one scrambling to figure out what this stuff even does. It's not right. This bill should go back. We should refuse to adopt. It should go back to conference where it can actually have a vetting in the light of day. I get it. It likely won't change. It might not change. But it at least deserves a vetting in the light of day when people actually have an opportunity to know what's going on. Because taking an entire omnibus bill from one bill and plopping it into another bill at 11 o'clock at night is a dishonest way of doing business. That is not transparent. Let's refuse to adopt and do this the right way.
I recognize the member from Pope, Representative Anderson.
Thank you, Madam Speaker and members. Good morning. I rise in support of the West resolution to send this back to the conference committee. And my concern with the bill is the recycling portion that requires those that really perform a service to our state and to our society by cleaning up areas that need cleaning up. To make those folks get a license, $250 a year, which seems a little bit spendy. I'm not quite sure their profit margins are large enough to justify a license of that size. And I had a fellow back home contact me when he heard about this possible licensing fee for recyclers, and he flatly told me that if this goes through, I'm done. I'm going to quit doing this. It just doesn't make financial sense. And just think if there's an abandoned trailer house that the owner wants to get cleaned up, or things like that, old batteries that are laying around. And before all of that goes, like the trailer house, for example, before that whole thing goes to the junkyard or the recycling center, he can go in there and take whatever is of value before it goes to the landfill. I should have said, take what's of value, the copper and such, maybe some of the wiring. And the interesting thing is that when he hauls those pieces of metal to the recycling yard in our area, the first thing they do is require him to give him his driver's license. He's already registered in the sense that his driver's license is put with that sale of scrap iron, so he can already be tracked. So I fail to see how having a $250 license would be any better than having the state and the recycling yard have his driver's license on file. They can track his sale if it appears to be too large, or if there's a bunch of copper wire missing from lampposts someplace. So again, this provision is unworkable. It will hurt the people that really help clean up sites that need to be cleaned up, and give them a little bit of a profit incentive, but this takes that away from them. So again, I support the motion to send this back to conference.
I recognize the member from Carver, Representative Nash.
Thank you, Madam Speaker. That was sudden. I would support the motion to not adopt. I have had problems with the Minnesota version of the California Consumer Privacy Data Act, or GDPR, or whatever you'd like to talk to it. I think that it's got a lot of onerous things that will be having to be ladled on top of businesses. I've been concerned with this for a long time. Representative Elkins is not surprised by this. I'm sure he was wondering why I hadn't popped out of my seat earlier. He's shaking his head. It's the caffeine, hasn't gotten there yet. But I just think that it is a provision that is better left to the federal level. You're going to have a patchwork because now there are a number of them that have been passed in different states, and I find it hugely problematic. It is going to be an extra number of steps for businesses that they don't already need. We had junk fees that they're going to have to take care of now. They're going to have to track that. This is another expense that they're going to have to do. They're going to have to go through more process and procedures. Once again, I know that the federal government moves slowly, but there are things that are better to be left to them to do, so that much like the one ring to rule them all, this is a better approach. I recognize Representative Elkins has worked on this for years. I've tried to kill it for years, so I guess you win today. But not if we don't send this back. We could send it back. That'd be a good idea. But I just think that this is another step that businesses are going to have to undertake that is not necessary, and that we should wait for the feds to deal with this in Congress. Thank you, Madam Speaker.
I recognize the member from Anoka, Representative Niska.
Thank you, Madam Speaker, and thank you, Representative West, for your motion. Thank you for serving on, I guess, the Commerce Conference Committee. I know you weren't expecting to do that. I was wondering if Representative Elkins will yield.
He will yield. Representative Niska.
Thank you, Madam Speaker. And Representative Elkins, I just wanted to double check, because I know you and I have had a number of conversations about this data provision. And can you just remind the body where this actually traveled through? I believe it did pass through the House in some bill, and help us to understand whether any changes were made from previous versions in the version that was put into this conference committee report.
Representative Elkins.
Thank you, Madam Speaker. Yes, this bill, the Minnesota Consumer Data Privacy Act, cleared all of its committees in both the House and the Senate. Along the way, there were 7 authors' amendments. And this conference committee report contains 2 last-minute corrections, one requested by the retailers, which just deleted some superfluous language, and one requested by the non-bank financial institutions who wanted the same kind of a carve-out that other financial institutions under state regulation had obtained.
Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Elkins, for highlighting those 2 changes. I did have another question, if you will yield.
He will yield.
Thank you, Madam Speaker. And Representative Elkins, was there any public testimony about those changes in the conference committee?
Representative Elkins.
There was not. These were issues that both the retailers had and the non-bank financial institutions had raised, but relatively late in the process. And by the time I was able to process the information I received, it was we'd already passed through all of the committees. So I would grant that that this is their first hearing on them.
Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Elkins, for explaining that. And I am more sympathetic, I guess, to the goal that you're trying to accomplish here than Representative Nash is. And I've appreciated a lot of the process that you've gone through in terms of the conversations. But this is pretty concerning that there were some last-minute changes made in this bill. A pretty significant change in state policy, and I appreciate that we're trying to align with some other states to make compliance as easy as possible. I did have a question for Representative West, if he will yield.
He will yield. Representative Niska.
Thank you, Madam Speaker. And Representative West, you referenced earlier a 9:30 p.m. call. I was just curious, how many hours after that call were you expected to vote on the provisions in the conference committee report, or approximately what time in relation to that 9:30 call?
Representative West.
Thank you, Madam Chair. Thank you, Representative Niska. Well, actually, I did misspeak, and I was wondering if he was going to correct me. Call was at 8:56, so I was wrong. 8:56, expected to vote on it around 13 hours after that. And at that point, I made 8 calls to many poor souls around here from 9 to midnight doing a crash course on the program. And honestly, I can't imagine people who are tracking this would think that it would end up in the cannabis bill.
Representative Niska.
Thank you, Madam Speaker, and thank you for spotting, I guess, Representative Stephenson another 34 minutes beyond your initial estimate. But yeah, this process is very concerning and should be very concerning to everyone. I would note, for those who are paying attention, this hasn't maybe been highlighted, but aside from Representative Stephenson, there were no House members of the Commerce Committee on this conference committee. There were folks who were engaged and interested in the cannabis issue. That's why I'm guessing you were on the conference committee, Representative West. But there was nobody on the Commerce Committee. And Representative Stephenson, I have appreciated working on the Commerce Committee, and there's been a lot of really good process. But this is not an example of good process, especially on some pretty significant policy changes, in particular, what I was just talking about with Representative Elkins. He has gone through actually quite a good process, similar actually to the process that you went through last year with House File 100, Representative Stephenson. And I remember having a private conversation with you after passage about at least the number of stops and how I appreciated the work to get a lot of input. And I have seen a similar effort by Representative Elkins. And so I think it's really unfortunate that at the end of that process that we had kind of really what I can only describe as some hijinks at the end. And I think that disserves Minnesota. I think that we should go through some additional process steps here and send it back to conference committee. And that's why I would support Representative West's motion to refuse to adopt.
I recognize the member from Sherburne, Representative Lawrence.
Good afternoon, Madam Speaker and members. Thank you very much. I'm addressing, and I agree that we should send this back and refuse to adopt this provision. One, I asked myself this very question: why do we have 3 different bills lumped into one? Very, very different bills. And I'm going to speak specifically to the recycling bill. I've had a chance to serve on the Sherburne County Waste Management Committee for many, many years. And it gave me an insight to our waste problem, to the recycling issues that we have, and a lot of different factors that go into that. And when you look at, and we've seen some recycling bills come through before, but this one being plopped into the middle of these other 2 bills makes absolutely no sense. And it's wrong and it's irresponsible for this very reason. The biggest problem we as a society have with recycling is finding people to recycle. Here we have people that want to recycle, that it's their business, their livelihood. Maybe it's extra cash on the side. Maybe they're teaching their children to recycle, and we want to place a fee of $250 on it. We want them to get a permit to do so when the profitability on their recycling efforts is not very good. This is one area where people are encouraged to recycle and the market dictates it. Government doesn't have to be involved on this level of recycling on any level. Every other one, we're trying to get people to recycle plastic because there's no market for it. Cardboard, the market is up and down all the time. Very little revenue for the people that recycle. All your other activities where people have to pay to recycle their refrigerators, their computers, all those other factors. This one in particular, we don't have to do a thing with. Government doesn't have to be involved on any level, and yet we want to come and stifle a recycling process that works completely market-driven. People willingly step up to the plate and find materials, whether it's aluminum, whether it's lead, whether it's copper, which is on this bill. They take it to the metal processors. They're compensated a fee for their efforts and for the products they receive. And I'm going to be honest with you, because we recycle our metals on our farm. We collect them throughout a year, and once a year we take them in. Not everybody works that way. That's how we do it. But the compensation isn't great enough to go every 25 days or every so often. It just isn't there. But it does work the way it works now. We are we are handcuffing this industry. We're handcuffing in people that rely on this as a livelihood. And we're taking money, once again, another tax with this fee right out of their pockets. Members, please vote with Representative West to not adopt this bill. This is irresponsible. Having this part in here in particular, I speak in opposition to extremely, very much, because I'm very familiar with it. I've had a chance to be a part of it. I've watched it operate. Do not handcuff or disturb this industry. It works as is. Thank you, Madam.
Further discussion. I recognize the author of the motion, Representative West. There being no further discussion, the clerk will take the roll. The chief clerk will call the names of the members voting remotely.
Carol.
Carol, no.
Carol, no.
The clerk will close the roll. There being 60 yeas and 69 nays, the motion for the House to refuse to adopt the report does not prevail. To the underlying motion, the Stephenson motion to adopt the conference committee report. Discussion. Representative West.
Thank you, Madam Speaker. Now I'll talk about the provisions I actually know something about. Unlike many people here, I do not like to talk about things I don't know anything about. So, what changed in this conference report? What modifications are being made in the end? The original cannabis bill, HF 100, was passed with a scoring system that's evaluated potential applicants based on the quality of their business plan, cultivation plan, wastewater plan. It made sure that the best are elevated and people who likely aren't going to cut it aren't. And then it provided a boost for social equity applicants. So a big concern of the other side of the aisle was, well, let's make sure our people benefit and get preferential treatment, but not so much preferential treatment that we don't even evaluate them properly. Now we're left in this conference report with a vetted lottery. Now I would argue, how can you have a vetted lottery? By the very definition, unless you're going to hand out multiple lottery entries to individuals who are eminently qualified, which, again, is a reasonable amendment I did bring forth in conference committee. Unless you're going to have a system like that, there is no way to actually have a vetted lottery. Because the very nature of a lottery is minimum standards. And not only is it all minimum standards, so it's just you have to, and we don't know what those minimum standards are. Those will be determined later by the department. But they also eliminated the property requirement to apply. So you say, hey, I want to go start a 30,000 square foot grow operation. Well, the first question I would ask is, where do you plan on growing? But no, that is gone from the bill specifically because they feel like, well, we don't want people to have too much skin in the game before they apply. We want to make sure people who can't afford to run a business have a chance to run a business and fail. It doesn't make any sense because in the bill it still says you have to have a security plan. But how do you have a security plan if you don't know the access and entry points of the property you're securing? Can't be done. You'll just say, oh, we'll have cameras. We'll have maybe a security guard. But will you? Because it's all minimum standards. There's no real evaluation. So when you have a system like this, you're putting it all up to chance. And you just pray to whatever God you choose that it all works out. I, for one, think we should help those who help themselves. It's like the man on the roof during a flood. He can't get out. Somebody on a boat comes to save him. The man says, No, I don't need your help. God will save me. Then a helicopter comes by and drops a ladder down to them. No, I don't need your help. God will save me. Well, unfortunately, that's the strategy being employed by the majority with a lottery system. And as you know, that poor gentleman never was rescued. And then when he saw God at the pearly gates, he says, "Why didn't you rescue me?" He said, "I tried, but you're too dang stupid to take my advice." So, in a lottery system, you could end up passing over incredible people. Like say Mark Cuban wanted to start a business here. Well, that would really help our market. But the way this is designed, it's like, okay, we want the barest bone minimum standards to ensure that, well, maybe Mark Cuban or maybe a competent business person like Damon John, but let's make sure that Chet, our friendly neighborhood drug dealer, gets a license. That is important. And, well, you know, maybe Chet's a great businessman. I don't know how long he's been dealing on the corner, but maybe he's good at it, but we don't know. And with a lottery system, we will never know until he fails or succeeds. This is compounded in this bill because with this lottery system, now there's caps on all these licenses, which actually I think the chair and author of the bill and I agree that this is a little dubious proposition, but sometimes you got to work with the Senate. Why do you want caps when you have no assurance that the people getting these licenses are going to be any degree of competent? You're just hoping. So if you do 15 licenses here, 20 licenses there, well, let's say 50% of the people are competent. Okay, so 50% of the business die or basically never get off the ground because this bill also gives them 18 months to utilize the license that they get in the lottery. And then if you think the promise was Q1 2025 when HF 100 was passed. But if we're going to say, oh, here's your license, you have 18 months to do anything with it, and people still haven't gotten those licenses, it's still going to be many months before they get those licenses, or several months. We'll see what the department does. They have 18 months to use it. So you distribute 25 licenses for like a mezzo business or something like that. And 12 of those are given to people who really have no business even attempting this. Then the remaining 13, well, this is a primary cash business. This is a very difficult business. Even very well-funded operations go out of business. It is one of the hardest businesses to be in right now because it's a federally illegal product. These people might succeed, but we're setting the market as a whole up for failure. And with how big of a priority this is for the Democrats, I'm surprised you're willing to take that risk. I am genuinely surprised because I would argue, you don't have a particularly good track record at setting things up. We've got MNsure, we've got MNLARS, and paid family leave's about to abundantly demonstrate this as well. You don't have a very strong track record. These problems are so obvious, they've been pointed out repeatedly. If any of you saw these hearings, I know I don't serve on Commerce, but some of my colleagues do, and you saw when they heard 4757, people lined up from across the spectrum, all sorts of different people, from very competent businessmen to likely Chet, your neighborhood drug dealer. We're saying, well, a lottery system doesn't make any sense. You pass this point system, which we assumed when you pass a law, that's going to be the law by the time the market starts. We've already been working towards this system. This system, we know that the quality applicants will have an advantage over the ones who have no business doing this. And now it's all up to chance. You can't put it up to chance. You can, but you put yourself in the hands of fate. And fate can be fickle. You never know when your time comes. Then we get to the social equity portion. So there was a lot of shuffling that happened in this, desperately trying not to have litigation on this front. So you've gotten very creative with what defines a social equity applicant. Now, I know this wouldn't be unanimous, but you'd find a whole lot more support for a definition of social equity that only relates to people directly harmed by cannabis prohibition. Now, some people would say, well, they knew the law when they broke the law, so they can pay that price. And I think that's a fair argument. But I understand the other side of, well, this was a bad law that really didn't do much good, and it was explicitly racist in some corners, especially coming from the White House. So, yeah, let's help people who were directly harmed. Absolutely. So, people convicted of a cannabis offense? Sure. People discharged from the military because of a cannabis offense? Sure. But just because you happen to live somewhere means you were harmed, even though it might have had nothing to do with you? It's ridiculous. It's genuinely ridiculous. So people are, not only are people getting preferential treatment who may or may not be ready to start a business, but they're not even somebody who, you know, needs some payback from the government, like somebody who was wrongfully imprisoned. So this definition is just all messed up, and it includes so many random people. So one thing I tried to get adopted in conference, because a lot of it was talked about in historic grievances, like historically this community has had this problem. But none of those communities are listed in the bill, so I don't think you're actually, well, one, being honest, but two, you're just trying not to get sued. So I thought, well, let's put women-owned business in here. I mean, you can't argue that women did not have a very difficult time. They did not get the right to vote until the 19th Amendment. They've certainly had a rough go of it historically. Well, I tried to get that adopted in conference committee, and it was unanimously voted down by the Democrats. So it's hard to figure out what you're going for there, because just look at the definition. They're wonky, and they're not actually helping the people who, I see an argument for people who are directly harmed. But we don't look for imaginary problems here. We should be working on real problems. So my prediction, so the promise initially was 2025, quarter one, for first retail sales. The department has admitted that's not going to happen. So we're looking out to the future, and now they're thinking maybe towards the end of 2025, and that would be incredibly fortunate if that actually happens. Well, maybe we'll have some retail sales, but it will be dysfunctional. We are going to see serious problems across the board. I would love to be wrong, but the track record of the majority does not inspire confidence. The obvious logical fallacies in this bill do not inspire confidence. And to boot, one thing that was often talked about was social equity applicants don't have access to capital. It's like, well, let's fix that. But there's the original requirement was the social equity applicant had to be 100% owned by somebody who falls in these categories. And then they lower it to 65% in the bill. And I had an amendment to make it 51% on the floor. Then I talked in private, hey, what can we do 55? And then in the last effort, I'm like, oh, let's do 60. Why? Because that restriction genuinely only hurts social equity applicants. You're telling them how much of their business they're allowed to sell. It's not your business. It's not your business. It's their business. They should have the right to sell however much of the business they want to. And there's no logical reason for that, and I do invite you to share with me, because when I brought that up in conference committee, I got, oh, well, stakeholders told us they don't like that. Oh, yeah, okay. Well, we're not here to do the bidding of other people. We're here to make good law. Well, actually, yeah, that sounded pretty stupid. Bidding of stakeholders. That laughter was very legitimate. We're here to do the bidding of the people we represent in a logical manner. It says right up there, reason is the life of law. So when you talk about stakeholders, I know you're not just talking about your constituents. You're not just talking about your constituents, you're talking about other people who honestly sounds like they have no idea what they're doing if they think the 65% restriction actually helps them. Because it doesn't. It's a restriction that makes it even harder for them to succeed and increases the odds of an absolutely disastrous rollout. So please, members, I urge you to oppose this conference report. It makes some benefit. Well, actually, I didn't talk about hemp. I'll really quick talk about hemp. So we had a lot of hemp businesses out when it was legalized a couple years ago that would sell a variety of hemp Delta-9 products. I'm sure you've seen them around. One interesting thing about HF 100 is it made a federally illegal product legal At the same time, it made numerous federally legal products illegal. It's ridiculous. So one good thing in this bill is my amendments around expanding the options that these hemp businesses have. They have more products that they have regained that were suddenly made illegal on enactment of HF 100 that will allow them to continue to succeed. Also, those businesses are required to register now, but they will receive automatic approval if they are in good standing, which is also a good thing in the bill, because we're talking about over 3,000 registered hemp businesses in the state. I bet you there's one in every single district or close to that. If those districts had to go through the if those businesses had to go through the application process, that would be brutal. They still do have to apply, but they know they are going to receive it. And the department can't possibly hope to resolve all that. So our hemp businesses that I think reside in every single district in our state do have some good things in this bill. But as far as the cannabis market, I mean, we are putting the fate of a new business in the hands of Chet, your friendly neighborhood drug dealer, and we just gotta hope against hope that Chet knows what he's doing 200 times over. So members, I urge you to vote red. Thank you.
I recognize the author of the motion, Representative Stephenson.
Thank you, Madam Speaker and members. I did just want to speak very briefly about a couple of things that Representative West just said about the timing of the market, because actually one of the things that we did in conference accelerated the launch of cannabis operations. We had, members might remember, as the bill left the floor, we had an August 1st date for when the department would announce the first round of licensing. That was a Representative West amendment that we accepted. Actually, in conference, we accelerated it further. Now applications will open. So the next step after an announcement is actually opening the application window. And that will start, that's in the bill, it will start on July 24th and close on August 12th. So we are in a strong position to get licenses out the door to folks and get cannabis growing by Minnesotans later this year, and hopefully sales to follow early next year. I did want to ask because I know he's a subject matter expert, I did want to ask Representative Garofalo if he'd yield to a question.
Will you yield to a question, Representative Garofalo? Sure. Representative Stephenson.
Representative Garofalo, I have a very important question, but I'm a little parched, so I'm just going to take a quick drink of water here while I'm drinking. And I don't know if you've seen this coffee cup before. I'm just reminded of it here. And now I'm a little distracted. I forgot my question, but Representative Garofalo, the Flow, Representative Pat, the Flow Garofalo, can you tell me, do you like this coffee cup? And tell us a little bit about this coffee cup, Representative Garofalo.
Representative Garofalo.
Well, thank you for the question, my friend, Representative Stephenson. First of all, I am not a subject matter expert on weed. I don't know what you're trying to imply there, but no, what you, I believe what you're holding up is perhaps my former friend Liz Olson might have given that to you, Representative Olson. Yeah, she apparently came across this old heirloom or whatever you want to call it. Once again, another former friend who's a legislator, Representative Matt Dean, in retaliation for a practical joke that I played on him, got about 24 coffee mugs made up with my high school graduation photo on it, where I have some much more hair than I have right now. So I believe that's what you were holding up over there. I'm trying to think of something witty to insult you with, but I got nothing right now, Zach. I got to tell you. Yeah, I'm just going to try to, sometime during session, I'm going to try to sneak over there and just smash it. So I think that, I don't know if that answers your question or not. So.
Representative Stephenson.
Thank you, Madam Speaker, and thank you, Representative The Flow Garofalo. And I'll leave the coffee cup here on the table for members from both sides to come in and enjoy a little bit. Thank you, Madam Speaker. I ask for a yes vote.
There being no further discussion, all those in favor of the motion to adopt the Conference Committee report on House File 4757, say aye. Those opposed say nay. No. The motion prevails. The clerk will give the bill its third reading as amended by conference.
Third reading, House File Number 4757, as amended by conference.
Third reading as amended by conference. Any further discussion? I recognize the member from Morrison, Representative Schultz.
Thank you, Madam Speaker. I'm going to get a little bit back to recycling for a moment and just want to talk a little bit about how this is going to work itself out. And I'm concerned because I think recyclers won't be able to do their good work. And there are exemptions in this bill for certain people who do business in this realm, and yet it doesn't take into account a lot of the people who work in rural Minnesota. And so I just want everybody to understand what this bill says on lines, let's see here, line 152.8, that if you don't have a license, the only dates that you are able to go and supposedly recycle copper would be on the first Friday of the months of April and October of each year. So 2 specific dates every year are the time when you can come and recycle copper without spending $250. And unless we want to send all of our recycling business to other states like North Dakota, South Dakota, Wisconsin, or Iowa, I frankly think this is pretty untenable and it's unworkable. Would Representative Hollins yield?
She will yield. Representative Schultz.
Thank you, Madam Speaker. Representative Hollins, this language that you've worked on this session mentions that if you're not a licensed actor as it relates to recycling copper or selling copper in Minnesota, that you can only sell up to $25 and that you can only deliver that to be recycled on 2 days in a year. Can you tell us how you arrived at that direction?
Representative Hollins.
Thank you, Madam Speaker. Thank you, Representative Schultz. This is fantastic. Great question. So the first thing I will say is I want to make it very clear that everybody can still recycle copper. There's actually nothing barring you from recycling copper. You cannot sell scrap copper if you do not have a license, unless it is during those 2 days of the year. Those 2 days were chosen as a concession because we were hearing from folks that there were a couple of people who maybe are doing a renovation, at-home renovation on their bathrooms or their kitchens, and they have some copper wire from that and they want to be able to recycle it. That is why, and they wanted to get money for it because they could have recycled it. You can recycle it, you just can't get paid for it. So we put those in as exceptions so that they would have that opportunity to still do that. What I do want to note is that scrap metal is actually defined in statute. It is not electronics, it is not batteries. It is very clearly defined in Minnesota statute that it consists of wiring and small amounts of copper metal. It does not include all the things that are listed here. And so in fact, people are able to bring those in and sell them however they want. I was, in fact, the bill author of the electronics recycling bill, and I would never want people to think that I don't want them to bring in their electronics to be recycled. I absolutely do, and that is not what we're talking about with this bill. With this bill, we are talking about small amounts of copper wire and copper metal. I will also note that we have 48 mayors from districts as diverse as Hastings, Fergus Falls, Dilworth, Red Wing, and Virginia, Minnesota, who are in support of this bill. And the other thing that I want to note is that the police chiefs are in support of this bill because it is something that is of deep concern to a number of cities across the state of Minnesota. So we added that exception in just to make sure that folks who are doing work at home have the chance to go in and actually sell that copper and make some profit off of it. But otherwise, yes, we expect folks to have a license or to be grandfathered in by being a part of a licensed profession, which are listed out in the language. Thank you.
Representative Schultz.
Thank you, Madam Speaker. And by the way, at least I haven't today, Representative Hollins, impugned your motives on where you were going. And I do appreciate the work that you've done to find balance and common ground to the extent to which you have in this bill. I do appreciate that. I am still of the opinion that this bill does need some work. It will need some work in the years to come because we want people to recycle, and we don't want to make it so burdensome for folks to do this good work. And you know, there have been examples that have been given by my colleagues today about the instances found in rural Minnesota. And those folks who work in this realm and help out, one, they're not criminals. And they're not in this arena to be stealing from others, but this is another tax on them through the lens of this license. They already do this work, and I think that this is overly punitive for them. And then in addition, to your point over the fact that, if someone's doing their own home project, the amount of scrap metal copper that would equate to $25, frankly, is not a very significant amount. And if they're going to be recycling this, I'm thinking that more often than not, we're going to find ourselves in a position where people are going to have to become licensed. So if they're adding on to their home, if they are building another shed, if they are doing this work, I'm seeing that the cost to do business in Minnesota will be $250 more expensive. At the end of the day, it's that. And so for us as a body and for the staff listening out there, I hope that when we're adding up the new taxes from the $10 billion that we were at before we started the 2024 session, I hope we add this $250 tax onto the list of new taxes, in addition to the $730 million of new taxes that were added and passed earlier this week in this body when the voices of the minority were shut out. So we have to make sure that we continue to recognize just how much taxes and fees in this state are being raised. And this is one big example that's going to hamper business in Minnesota and make it more difficult for people to do the good work of recycling in communities all across the state.
I recognize the member from Ramsey, Representative Hollins.
Thank you, Madam Speaker. Just want to put in there, the voice of the minority were shut out, and yet we have an exception for auctioneers in our copper wire language. Interesting.
I recognize the member from Anoka, Representative Niska.
Thank you, Madam Speaker. I'm not sure how to follow that exactly. I'll just make a couple of big picture points. Like Representative Schultz, I don't question the sincerity and the motives of Representative Hollins. I just did want to make a couple of big picture points about both the copper theft provisions and the ways that the cannabis licensing provisions are being changed. And just to think about generally as we talk about issues around lobbying, the ways that the perspectives that get heard here and those that don't get heard here, and the process that we have gone through. I think, first of all, I certainly understand, Representative Hollins, where you're coming from, and I do appreciate the ways that you have had conversations, apparently with at least one auctioneer maybe, but with other people around issues dealing with copper wire. I do think we do, and the majority seems to have a misplaced emphasis when we're talking about crime with regulating people who are trying to obey the law and operate lawfully in our economy, and not enough of an emphasis on making sure that we deal with the people who are stealing the copper wire out of the, as just one example, but criminals in general. I think that should be more of our focus in thinking about crime. I wish that was more of the focus from the majority. I do, though, want to talk a little bit about, we've heard a lot of stuff on the floor here, especially over the last few days, talking about how horrible lobbyists are. But I think it's important that as we, look at some of the discussions around this bill about the data privacy provisions, about the, who's getting consideration relating to copper wire. There are a lot of people who don't know what's going on here at the Capitol, who might not be able to hire lobbyists at the Capitol, who are being affected by some of the general rules that get put into place. And then, the folks who are more engaged tend to get consideration. And I think that's good to the extent that we are listening to people's concerns about the regulation that we're doing here. But I think it should tell us that we should all be a little bit more careful and humble about the general rules that we apply and think about what are the voices that maybe we aren't hearing that are going to be affected by our laws. And I think this ties back into the concerns about the process that was followed here. Who has been able to follow, who was able to follow what happened in the dark of night between 8:54 and then the vote 13 hours later, for example. So that causes me some concern. And then I'm also just concerned generally about the ways that the cannabis licensing provisions were changed from last year to this year. I think there were a lot of people who, and we heard a lot of testimony about this in committee, Representative Stephenson, people who were thought they were on one track, and then there was a little bit of a bait and switch, perhaps, in terms of the way the licensing works. Obviously, I have very different views about whether we should have gone down this road in the first place, but once we did go down that road, I think we need to be very careful about kind of pulling the rug out from people who have put money and time into a certain licensing provision or licensing regime, and then we change it. So for many reasons, I think that this bill just isn't ready to be voted on yet. I'm not going to be voting for it, but I think those are things we should be thinking about more generally as we look at the work that we do, the ways that we change the regulatory landscape for a lot of people, and sometimes without hearing all of the perspectives that need to be heard about it. Thank you.
I recognize the member from Hennepin, Representative Bonner.
Thank you, Madam Chair and members. There are some wonderful provisions in this particular bill, but I think it's probably not a surprise to anyone that I want to speak specifically to the Minnesota Consumer Data Privacy section. This bill has undergone extensive vetting over multiple years. I want to commend Representative Elkins. For folks who do not work with him every day, I liken him a little bit to like the Terminator. He sifts through the data, piles and piles and piles of it, and he assembles it very carefully, like a finely tailored glove. He consulted with industry experts across the spectrum, some who, candidly, I'm not sure I would have wanted to listen to as closely, but he was so patient and so kind and listened to each and every concern. And even the concern that was brought up recently about the two recent changes, despite years of work, at the last minute, business interests came forward with concerns. He heard them. He took them into account, decided that they were reasonable, and incorporated the requests of businesses into the bill. That's good legislative work. As for the patchwork that we spoke to earlier, I think we all know that we would love to say that the federal government and that our federal partners are always on top of things. But let's be honest, every member of this chamber is well aware that that rarely ever happens. And in fact, it is state legislators like ours that often serve as the laboratories to test out ideas, to build them, to refine them, and to make them great. And what we often see is that eventually, after friends like Representative Elkins have done all of this fine, hard work, that the feds swoop in and they say, that was a darn good idea. We should do that. And they adopt it on the federal level. And now, granted, this bill has been through 15 different states. It's been through lots of pieces. But I will say, what I can say without a doubt is that this particular version of the bill is, in my estimation, and that of many folks within the industry who have worked very closely with Representative Elkins, it is by far and away the best version of data privacy in the country. And I want to say that people in Minnesota expect a higher level of data privacy. This is about consumers, friends. This is about giving people the ability to control their own data. In the day and age in which we live, and on the precipice of all of the changes coming from AI, this piece about data privacy becomes more important than ever before. And we are doing this before those changes occur. We are putting those guardrails in place to ensure that Minnesotans have a higher level of data privacy, and I know that many of my friends on the other side of the aisle share this concern as well. We've heard it across the board, and in particular, I know while Representative Scott is not on the floor right now, I know she in particular is a champion for data privacy and for our consumers on this front. And for those reasons, I will very proudly be voting yes on the Commerce Bill. I want to thank Chair Stephenson for all of his hard work, for all of the committee members and folks who have put together this bill and expertly weaved it together. But in particular, I want to say a great thank you to Representative Elkins for all of his hard work on this bill, and I am proud to vote green.
I recognize the member from Chisago, Representative New Brindley.
Thank you, Madam Speaker, and members. And in fact, I was just having a conversation about a provision in the bill that I'm going to take a few minutes to explain. And if I miss anything, I hope that some of my Democrat colleagues will fill in the blanks. First of all, just quickly to touch on, thank you, Representative West. Frankly, there's kind of one issue in the cannabis portion of this bill that I care about, and we talked about before, and it's this lottery system. You know, we've got a situation in my district where we have 3 folks who want to start a grow operation. They're all equity applicants. One of those 3 is clearly prepared to stand up a business. And the other 2 really are not. And so while they are on equal footing in the lottery system, they are not on equal footing in their real life ability to stand up a business. So frankly, again, cannabis is not my issue, but doing good work is my issue, and doing things right is my issue. And frankly, that's just a bad way to do business. So I said my piece on that. I want to talk for a minute about the 340B provisions included in this omnibus bill. And this is actually what I was really sort of trying to pay attention to. And Representative West stepped off the floor, but he knows the morning that this came out, I went, what? Commerce was just dropped into cannabis? I had no idea what was going on. But this 340B provision is one that we did hear in the Commerce Committee. Now, we did not hear it in the Health Committee, where it would have appropriately been heard, because that is actually where the members of the legislature who work on 340B issues serve. It's those of us on the Health Committee that work on these 340B issues, and probably it is complex, but we probably at least have a little bit more understanding of that issue. But it didn't go to the Health Committee. It only went to the Commerce Committee, which is probably not appropriate to begin with. But I want to draw some attention to things. It's interesting. We had a hearing in November, I believe it was, of the Health Committee, and one of the presentations was on the 340B program. And as you all know, I save everything. I've got it right here, and I pulled up my presentation, and it's sort of funny to watch my evolution through the presentation. Because at first I'm making snarky notes, and because my bias was towards the 340B program. Frankly, it is a program that helps fund our hospitals. So my bias was absolutely toward the 340B program. And my notes as we go through that hearing on the 340B program changed. And at one point, I have large circled in my notes, this is about the entity that is capturing the profit. That's what was said in that committee hearing. The 340B program is ultimately about, when we distill this all down, what entity is capturing the profit on these medications, on these prescription drugs. That's really what this is about. Okay, so that sort of sets the stage for this 340B. It's a federal program. The feds decide which entities are 340B entities, QHPs, hospitals, The feds set that. We don't decide that. That's already decided who is a participant in the 340B program. And when hospitals have an in-house pharmacy, it's very easy that that's the pharmacy that they work with to receive the benefit of 340B pricing. Now, what that means is that the hospital pays less for a 340B approved drug. So they are paying less than what the drug actually costs, and then the hospital gets to capture those savings. So that's how the hospitals or the QHPs, quote unquote, profit off of this. That's how the hospitals become the entities that capture the profit. It's by booking those savings, really. It's not like they're getting a cash payment, they're booking savings. And then these are purposefully unrestricted funds. And the idea is these are supposed to be serving underserved communities. These are safety net hospitals, again, QHPs. These are the folks who are supposed to be serving our underserved. So that's done purposefully, that these funds are unrestricted. That's done on purpose so that then these hospitals can take those savings and use it to serve their community in whatever way they need to do that, right? In the best way to serve their community, to make sure that they are being provided the best health care that they can get. That's sort of the very high level, fundamental, this is what the program is, this is what it is supposed to do, okay? Which is why, again, my bias was toward the 340B program. And again, through the course of this, through the course of the hearing, my sort of questions in my mind changed, and my bias shifted a little bit. Now, the problem we have, well, I apologize. I emailed out a couple of articles to everyone. One of them I couldn't get to print very well, so I emailed it, but I did not print it for you. Another one is a rather lengthy study, so I printed out the executive summary for you and passed that around, but the full article is in your inbox. I emailed it to everybody. But in the article, one of the articles, the article from the Reformer, now this is just from last month. There was an article in the Reformer, and Saya Nikpe was quoted, and she's actually the person from the University of Minnesota who came and presented to the committee. And her concern actually is that this is all being dealt with in Congress right now too, because there are a lot of problems with 340B. And so there was a House Health and Finance and Policy Committee in December, and after doing extensive research on the 340B program, this is what they said: my research finds that the 340B program creates perverse incentives for covered entities. I have used large nationally representative administrative data sets to show that, number one, hospitals that begin participating in the 340B program, quote, do not meaningfully increase their safety net engagement, which is really the purpose of the program, right? Is to be able to fund that safety net engagement. Number two, the 340B program's eligibility criteria poorly targeted safety net providers. Now, I will not call out any entity specifically. If others want to do that, they can. But we have providers. Many of our hospitals in the state are running in the red. Some are in the black, and they are also part of this program. I think you'd be surprised to know all of the entities that are eligible for 340B. And three, contract pharmacies. This is the important part regarding this bill. Number three, contract pharmacies are less likely to be located in medically underserved areas or areas with higher uninsured rates. That's really the crux of the problem with what we are doing to expand this bill. Because in this bill, we are saying that pharmaceutical manufacturers are required to recognize any pharmacy as a contract pharmacy, any and all pharmacies as contract pharmacies. And again, contract pharmacies are less likely to be located in medically underserved areas or areas with higher uninsured rates. Now, let's talk about how that's happening. In the other study that I passed out, and I want to point out, this study was done by the North Carolina State Health Plan for Teachers. So that's who commissioned this, and this was done with the state treasurer of North Carolina. So that's who did this study, and this is what they said, and this is why I passed out the executive summary, because you at least get the top line right off the bat. North Carolina hospitals use the safety net 340B drug pricing program to overcharge cancer patients, state employees, and taxpayers for oncology drugs. Now, how does that happen? This happens across the board. It's because the savings from 340B are not passed on to patients. It is the entities that capture that profit. These savings are not being passed on to patients. They're not. And not only that, further in the paragraph it says, hospitals pursued higher profits by expanding into wealthier neighborhoods with higher rates of health insurance. Let me explain this. So what that means is that they are now paying less for the prescription drug. But when you've got a highly insured population, they're paying less for it to put it in their stock, to have it in their inventory, but then the payers are paying them full price. Whereas if they were in an underserved area where more folks were part of the Medicaid population, their reimbursement would likely be less. Now, to Representative Liebling's point that she has often made, actually, since we do contract with MCOs, there's a capitated rate, and it is actually likely closer, at least, to a fully insured market. We don't really know, but that's possible. But regardless, they're using these in areas where a large percentage of the population is fully insured with commercial coverage. So they're banking savings by paying less for the drug, but then they are being paid full scale for it. And that's what the pharmacies are capturing. That's what the pharmacies are capturing that way. And so again, the problem is that contract pharmacies are less likely to be located in these medically underserved areas. In the Reformer article, there are a lot of really good nuggets, and I hope you all take the time to read it. It says things like, there's a bill pending in the legislature that would enable the prosperous to profit over the poverty-stricken, and there needs to be a bright light cast on what's happening before this imbalance is codified into law, which is what I'm trying to do here. I'm trying to shed that bright light. And I wish I had known. I did certainly make all of this clear in committee as well, but I did not realize that this was being done at 11 o'clock at night. Says, unfortunately, over time, the tens of billions of dollars flowing through this program have proven irresistible for for-profit corporate entities, including giant health systems, and this is the part I'm more concerned about, big box chain pharmacies. And there's no guarantee that those discounts are receiving the patients, are reaching patients. In fact, we know that that's not the case. There is no requirement under 340B that any of these savings reach patients. And in fact, it's almost the opposite. It is designed so that these savings that are booked are unrestricted. They're unrestricted. Last year alone, large chain pharmacies like CVS, Walgreens, and Walmart, and pharmacy benefit management companies like Express Scripts and OptumRx took $3 billion out of the 340B program. As the number of 340B contract pharmacy arrangements has exploded by more than 5,000%. Now, let me tell you why this is significant. I've been very honest from the beginning on this 340B provision. I said this in committee when I spoke with Representative Liz Lagarde about this. There will be a nominal benefit to hospitals from passing this legislation. There will be a nominal benefit. But most of that benefit is already being captured. The vast majority of that benefit is already being captured. So there will be a nominal benefit. Where the real benefit in this is, and why I have a problem with it, is that this is a massive transfer of wealth from one big for-profit company to another big for-profit company. And I don't know why, as a legislature, that is our job to facilitate. It's not our job to facilitate. But that's really the real boon of this legislation, is that this is a transfer of profit from big for-profit pharmaceutical manufacturers to big for-profit pharmacies and PBMs. That's the real effect of this bill, with ultimately no savings for patients. Patients will not see a dime of this money. Not a dime. So I get that this is big and this is complicated, which is exactly why this bill should have gone to the Health Committee if it was going to be included in a budget. If this bill was going to become law, this should have gone to the Health Committee, because we're the ones who deal with these issues. I get it, most people's eyes glaze over when we start talking about this, but it matters. It matters a lot, because we have a lot of people profiting off this, with patients, with people in need of these services not receiving any of the benefit. It's a terrible policy. It's a terrible policy. It should not be the state facilitating a transfer of wealth from one big for-profit to another big for-profit. It's a terrible way to do business. I don't know where the cronyism is in this, but it's bad. It's bad. I will be voting no on the bill today.
Further discussion? There being no further discussion, I recognize the author of the motion, Representative Stephenson.
Thank you, Madam Speaker. I do just want to briefly speak about the 340B provision because for a few reasons. One, I do want to reiterate that provision was heard in the House Commerce Committee. It was not heard in the House Health Committee. It was heard in the Senate Health Committee. It got all the way through the process in the Senate, was brought to conference by the Senate. So there was a lot of opportunities for the public to weigh in, to provide testimony. And, you know, this is a program for which there are legitimate questions and concerns, which is one of the reasons why I'm so pleased that Chair Liebling, I think last year and maybe making some additions this year, is doing a really deep investigation into the 340B program and having reporting requirements and further modifications that are coming out later this year, which is one of the reasons why, while we accepted the Senate language on 340B, we did sunset it. We put a sunset in statute. So the language that's passing today will sunset in 2027, absent further action from the legislature, which gives us the opportunity to look at the report that Chair Liebling has allowed us to have, which I think is really important. And we had a lot of conversations about that. and whether we should just wait for the report before doing this. But, you know, Representative Brindley said it, that there's a lot of hospitals in the state that are really in trouble. And the place where they're particularly in trouble is in rural communities. And I know that's what Representative Lislegard, who's the author of this provision, is primarily concerned about. And he has been a real champion to try and make sure that the healthcare providers that serve his communities are able to stay open. Because all across the state and rural communities, we are losing healthcare providers. And this program will provide a much needed lifeline to a lot of rural medical centers. And so it's important for us to pass this today. It's important for us to take a look at the information that comes from Chair Liebling's work, and then we will need to revisit this program in the future. But if you want to save your rural health community, if you want to work to protect those small providers, it's time to follow the leadership of Representative Lislegard and cast a green vote today.
The clerk will take the roll. The chief clerk will call the names of the members voting remotely.
Carroll.
Carroll, aye.
Carroll, aye.
The clerk will close the roll. There being 68 yeas and 60 nays, the bill is repassed as amended by conference and is titled agreed to. We'll revert to reports of standing committees and divisions. A copy of this order of business is on your desk and online. If there's no objection, the reports will be adopted. Hearing no objections, the reports are adopted. Second reading of House bills.
Second reading, House Bill number 5435.
Second reading. Okay. Conference committee report.
Conference committee report on House Bill number 5216, an act relating to state government, providing law for judiciary, public safety, and corrections. The report is addressed to the Honorable Melissa Hortman, Speaker of the House, the Honorable Bobby Joe Champion, President of the Senate. We, the undersigned conferees for House Bill number 5216, report that we've agreed upon the items in dispute and recommend as follows. The report is signed by 4 of the 5 members on the part of the House and 4 of the 5 members on the part of the Senate. Moller moves that the report of the Conference Committee on House Bill number 5216 be adopted and that the bill be repassed as amended by the Conference Committee.
I recognize the author, Representative Moller, who will explain the report.
Thank you, Madam Speaker. I will explain the public safety provisions of the report, and then Chair Becker-Finn can explain the judiciary provisions. First, I just want to thank you, send a thank you out to the staff who worked so hard to get this bill together. Also to the conferees and the members of the Public Safety Committee. Thank you to Representative Moller for your work both in committee and as a conferee. The funding in this bill is very similar to the funding that left the House floor. When we were given about $10 million in one-time funding, and almost $9.5 million of that is going to victim services programs. The other funding in the bill really is for Department of Corrections deficiency funding, and that is to pay the salaries of our correction officers. Really important funding there. And then a new provision I want to highlight is not from the general fund, it's from a special revenue account, the digital GIS mapping of schools. That's going to make it so that we can have a mapping of our schools so that if there's an emergency in a school, law enforcement will know and other first responders will know exactly what location that emergency is occurring in and can get to that location quickly. Of the policy provisions that we had in our policy bill that passed unanimously off the House floor, we have nearly all of those provisions. One provision that the Senate did not adopt was protections for privileged communications of domestic violence victims and their advocates. That was deeply disappointing, but mostly all of the other provisions that were in the House bill were adopted by the Senate. There were other bills we had that were rolled into this, including Representative Pulowski's bill, which I think also had unanimous support related to the disaster contingency funding. So if there is a disaster this summer, members, and we don't have enough funds in that account, we will not have to come back for a special session for that. And the language changed a little bit after we talked to the Senate, but ultimately it's set up in a way that we can always keep that account funded in order to avoid having to come back and replenish that really important account. So some of the policy provisions that we took from the Senate, there are a number of provisions related to higher education for our folks who are incarcerated, really to work on rehabilitation, just to make sure that they have the skills they need when they are leaving and re-entering our communities. I also wanted to highlight a bill that's in here related to collateral consequences. This is something that had been worked on for years in a bipartisan fashion. The bill itself in past years was very complicated, and the Senate had a really good provision that's a streamlined version of this that's going to have a list on a website by the reviser of potential collateral consequences for a conviction. So it's sort of a one-stop shop where people can go and look at that, and it's really informative to the public. And then we do have a number of Republican provisions in this bill, most of which came either off the floor individually or were in our bill. We have Representative Leader Damas' swatting bill. We have two provisions from Representative Nash, including the mandatory reporting of child mistreatment, Representative Ween's Veterans Restorative Justice Act, Representative Rarick's Predatory Offender Registry Reform. We have Representative O'Driscoll's Level 2 sex offenders notification bill. We have some order for protection provisions from Representative Erdahl, and we have Representative Mueller's therapy dogs for law enforcement and fire. We also just, in a lot of our language, even in addition to these bills, had input from our GOP members, especially in committee, and made our bills better throughout the process. So thank you for that. We do have a number of victim-centered provisions in this bill as well. I mentioned the victim services funding. There's victim input and end of confinement review process. There's a bill that allows for sexual assaults to be tried in a county, either where a victim was assaulted or if she's mentally incapacitated, where the victim is discovers that. We also have a bill related to private prisoner transports, which was a response to sexual assaults by private contractors to eliminate that from happening anymore. A couple of provisions related to orders for protections that are beneficial to victims, and then several agency provisions related to victim notification and protecting data that victims submit for their sexual assault kits to be paid for. So there are a number of our provisions, like I said, continued to be in this bill. Thank you.
I recognize the member from Ramsey, Representative Becker-Finn.
Thank you, Madam Speaker, and I will go over the judiciary portion. The finance provisions are very close to what left the floor here, with primarily the focus being on forensic examiners, interpreters, as well as court cybersecurity. So no major changes there. In the policy sections, we did, although in the public safety section, but a bill that I was chief authoring on the sale of human remains, we did get some language that allowed us to expand that to include not just calcified remains, but all human remains. And I do want to thank staff for being very diligent to make sure that there were no unintended consequences with that language. Related to that, we also added a provision from the Minnesota Indian Affairs Council that if probable American Indian remains are disturbed, that there will be a process and notification in place. Other policy provisions, as far as the judicial data privacy, I know there were questions about that when it passed off the House floor. The Senate language did have quite a few exceptions, and this bill does include those exceptions. I know that there are judges and their staff who would like to see this go further, and I expect that Representative Curran will continue to work on this issue and fine-tune this in future years. There's also a provision relating to HOAs and childcare, which was a Representative Hemmingson-Yeager bill that came in from the Senate, as well as a contract for deed reform, which also the Senate Judiciary was carrying it in their Judiciary bill. We didn't necessarily carry those provisions in the same path, but they came in from the Senate and are in the bill before you. There are also some data and privacy provisions that passed off our floor in the state government bill from Chair Cleavorn, including the cybersecurity reporting bill, as well as some updates to the Office of Administrative Hearings, just modernizing some language there. So those are the major differences. Not too much different, just some additional helpful things that are in here. We also have the UPEPA bill, which is the public expression bill that passed off this floor with bipartisan support, but did not pass as a standalone in the Senate. And then also just do want to thank Representative Moller for updating the language on the therapy dog grant program to include firefighters as well. So that is the bill, and hope members can support it.
Is there a discussion on the conference committee report? I recognize the member from Moller, Representative Moller.
Thank you, Madam Speaker, and thank you, members, and thank you, Chair Moller and Becker-Finn, for having me on the conference committee. It was the first conference committee I ever got to be on, and so that was really exciting. And I'll tell you, I guess I'm very excited that I voted for this bill when it went out the first time, because exactly what I thought would happen is what happened. I was given this bill. This is a little over, 250, almost 300 pages long, at 11:30. We were able to have a walkthrough, which I appreciate. And then we were told we were going to have conference committee at 3:30. There's going to be no other, looking at what the Senate has, look what the House has, figure out negotiating back and forth, listen to public testimony. This is the bill. You get a time to offer any amendments that you can scrap up in an hour and a half. Thank you so much to our staff. And then vote on this. A bill that affects everybody's life, including and especially our police officers. There's a couple provisions in here that are still incredibly opposed by our police officers, including changing the training that they had for how to approach a vehicle when they stop it for equipment violations. And again, there has been comfort language that was added to it. There was explanations for it. And instead of listening to our professionals that said this is the type of thing that we should be working on through the post board, if we have it, let's actually use it. No, we as a legislature is going to do it, even though it's incredibly unpopular. I appreciate the fact that we had the opportunity to offer amendments, that we had the opportunity to express what is our side of the aisle, how we feel about it. And there are so many good provisions in here that are worthy to be supported, and we already have. Members on this side, we already have. We have supported these. And yet, This process, again, we're finding a theme, Minnesota, we're finding a theme. Don't have enough time, quick, dump it in another bill. Don't have enough time to get public input, quick, we negotiate in the dark of night. And then just vote on something that was put together by maybe two or three people. It's supposed to be an open process. Now, I know that this was my first conference committee that I've been appointed to, but I have been to several in my first term and in my second term where I've watched it. And I've watched the collaborative effort that the bodies are supposed to be working together. I've watched that process where they go through the bill section by section to find where we can either maybe dump certain languages or we could compromise on something. I've watched that process. And this did not happen in public viewing. The compromise and the collaboration and the negotiating did not happen in front of the public. And frankly, didn't happen in the presence of the minority party either. And so I think, while I cannot imagine a better policy bill that we had earlier, and the funding that we're putting towards crime victim services, so important. The funding that we're putting forth for our security officers in DOC, invaluable. This is the type of focused funding that we should be doing. And I agree with Representative Otney. We wish we could have done more. Wish we could have done more for these. But because of the process of this, I would urge members to vote red on the adoption. Thank you, Madam Speaker.
I recognize the member from Meeker, Representative Erdahl.
Thank you, Madam Speaker and members. I just want to highlight a provision in this bill from a bill that I had. I would like to thank Representative Moller for including in this the provision dealing with a young boy from Olivia who intervened when a man was assailing his mother and instead received the knife intended for the mother and died. The guardian of this boy did not know that the order for protection had been removed on the man that was with his mother. He would not have been in that circumstance had she known. And because of this bill, in the future, guardians will have to be alerted if there are changes in orders for protection involving their charges. So we'd like to, I appreciate that Isaac is going to be remembered in this legislation. Thank you for putting it in.
I recognize the member from Anoka, Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Mueller, for your service on this conference committee. And thank you to the other conferees, and thank you, Chair Becker-Finn, for your work on all these judiciary issues and the conversations we've been able to have around them this year. There's a lot of good stuff in this bill, for sure. And I do wish I could support it. I wish it would have been, maybe we would have put some of the policy stuff in a cleaner bill without additional spending. I know there's a lot of concern from folks on this side of the aisle about how much money we spent last year, where the fact that we're headed for a deficit next year, and even things that we would like to have spend money on, it's difficult for us to vote for spending on things that weren't enough of a priority to fit within the huge spending spree that happened last year. But I did want to highlight three kind of specific places. A couple of them are places where I think we're going in the right direction, but I think there's a little bit more work that's needed on this. So Chair Becker-Finn, you mentioned the human remains provision, and I do salute the work to expand this, and I think that you, it seems like you genuinely heard the concerns coming from this side of the aisle about whether we needed to have it as limited as the original version that was passed off this side of the aisle. So off this House in the first place. And so I do genuinely appreciate that. I do have a little bit of concern though with the way the language reads. And so I was wondering if Chair Becker-Finn would yield to a question.
She will yield. Representative Niska.
Thank you, Madam Speaker and Chair Becker-Finn. So on page 104, the way that this statutory language reads, starting at page 104, line 4, it says, except as provided in paragraph B, a person is prohibited from selling human remains or offering human remains for sale. And then paragraph B says, shall not be construed to limit the donation of human remains. And so my concern with those two things is the way I think, and I think the definition or meaning of sale and donation is that they're two separate categories. One is offering something for money and one is offering something for free. And so I'm concerned about using except as provided in paragraph B, and then paragraph B is only about donation. So except as provided in paragraph B, you can't sell, and then paragraph B is only in donation. And so maybe that should have been worded more clearly, but I just want to clarify for the record. First of all, I think we could maybe go back to conference and reword that a little bit to remove that ambiguity. But if we don't do that, I do want to just ask for the record whether this intends for all sales to be prohibited and only donations to be legal.
Representative Becker-Finn.
Thank you, Madam Speaker. I don't think the courts would have any problem understanding this, so it's not going to get to intent in the first place. It's just making it clear that donation's okay. And the things that are listed here are things that law enforcement asked for. We also updated some language that one of your members asked for as far as search and rescue operations and those who cadaver dogs and folks who do that kind of volunteer work as well. It's very clear to me that it is simply donation is allowed. And then if you go down to D, we do want to make sure that folks can be reimbursed because there are costs in handling remains properly for the delineated purposes.
Representative Niska.
Thank you, Madam Speaker, and thank you, Chair Becker-Finn. I think and I will try to restate that, and if Chair Becker-Finn will yield to correct me if I say this wrong, but
she will yield.
I think what you said, and I just want to try to restate it as clearly as possible. All sales are prohibited but donations are allowed, and included within the allowing of donations is reimbursement of expenses. That wouldn't be considered a sale, that would be considered part of a donation. If I said any of that wrong, I hope you'll correct me, but I'm just trying to make sure that this is 100% clear, and I do appreciate, again, I really do appreciate the work that you've done on this issue.
Representative Becker-Finn.
Yes, thank you, Madam Speaker. And I will note for the record, it's interesting how much discussion we've had on the House floor about this provision. Nobody's ever brought this issue up until actually one of our staffers experienced this out in the world and asked me if it was illegal, and I looked into it and it wasn't. And so I think it's good language. We've worked closely with our very good nonpartisan researchers to get this to the shape that it needs to be. You can't sell and buy human remains. That's what this is. That's what the bill says. You cannot do it. You cannot do it for profit. That's not the goal here. We just are making it clear that there are legitimate purposes, including in the medical and drug development space. There are legitimate reasons for donation. There are legitimate reasons in educating future doctors and such. I think it's good language. I think it's clear, and I hope that folks can support the bill because it is important. And I will note it's important enough that we made sure the effective date is immediately after it's enacted, so we're not waiting until August 1st for this to take effect.
Representative Niska.
Okay, thank you, Madam Speaker, and thank you, Chair Becker-Finn. I think you're agreeing with me. So I think we're on the same page. I will note that I wish that I I had a conflict the day this was in the Commerce Committee. Obviously, I wish I had a chance to discuss this with you before, but it sounds to me, and the way I'm reading this, the language and the way I'm understanding it, like we're on the same page. I think it could be slightly clearer, so I do think it could be sent back to do that. I do have another, and it's just kind of in the same vein, actually, on the UPEPA provision, a bill that I co-authored with Representative Frazier. Is he over there? I can't tell. Is Representative Frazier?
He is not on the floor.
Okay. I do have some concerns about the process of that surrounded UPEPA, and in particular some of the conversation that we had in committee around it, and in particular the exemptions that were added in the committee, and concerns that were raised with me, and I know that were raised in the Senate after we passed it out of the House, relating to the way some of the exemptions, in particular the exemptions on page 256. It doesn't apply to a cause of action on page 256-29 based on common law fraud claim, and on 257-8 brought under consumer protection. These are not part of the uniform provision. They do track, I think, Washington. And I don't think it was necessary for us to put these in. The answer that was given when I asked this question in committee was that we were trying to align it with the state of Washington, if I'm remembering correctly. There was at least one other state. But some of the, it's not part of the Uniform Law Commission's version of UPEPA. And I did go back and look at some other state SLAPP laws, and there are instances, quite a few cases actually, where SLAPP laws are applied, especially in California, to consumer protection claims or common law fraud claims. And so I wish we would send it back and listen to some of the concerns that have been raised while we're still in the process. That being said, like the human remains issue, this is a situation where I generally agree with the thrust of where these policy provisions are going. And so I do think both of these provisions are better than the status quo, I will say that. But I do wish we could send it back to conference committee, and for that reason, I do support Representative Mueller's motion. The last point I would make is there was an opportunity in the conference committee. Representative Moller carried an amendment that I had helped her with that would have put some clarity around the bias registry, the civil rights trends language that we passed last year in the Judiciary and Public Policy Omnibus Finance and Policy Bill, or Public Safety and Judiciary Omnibus Finance and Policy Bill. I think I got that right. Where there was a claim made by the majority that we were taking out a database of speech at the Department of Human Rights. That really didn't happen in the bill last year. We, in fact, funded what could be used as a bias registry at the Department of Human Rights. And the Commission of Human Rights and news reporting on this has been very cagey about what, in fact, they are doing at the Department of Human Rights. I think we'll have some questions around that, but Representative Moller offered an amendment in the conference committee which would have just used the protections that we have in UPEPA, the way that we define protected speech in UPEPA, and said the Commissioner of Human Rights can't have in that department database any collection of protected speech. So I think that it would have been good to have clarified that in this bill as well. Representative Moller, did you move to send this back? No, we're on adoption.
Representative Niska, you do not have, this is not a quorum to ask a member a question on the floor.
Sorry, Madam Speaker. It was noted to me that there hasn't been a motion to refuse to concur, and so I would move to refuse to concur and request a roll call.
Representative Niska moves to refuse to concur. Seeing 15 hands, there will be a roll call.
Thank you, Madam Speaker.
Discussion to the Niska. The NISCA motion to refuse to adopt. Representative Brindley, I know you were on for the, okay. Further discussion on the refuse to adopt. There being no further discussion, Representative Johnson.
Madam Speaker, Representative, thank you for your motion to not concur. Members, we've gotten to a bad habit lately. Started a couple years ago. It was even worse. It was bad last year, and this year's even worse. We have conference committees for a reason. That's for each body, the House and the other body, to sit down to hash out the differences. With what's been going on, we might as well forget about that, just have the authors of the bill go over there on each side and talk about it. We don't have conference committees anymore. Here again, there's 5 members, I believe it was 5 members from each body, and 2 members in the dark of night in a back-filled smoked room decided what was going to be in this bill. No opportunity for amendments by the minority because they weren't in that back room. We don't know who was because we have no idea what was going on. This is a poor example of how the People's House operates. No transparency, no input, no testimony. Absolutely ridiculous and shameful. We have rules, and the rules say how they operate. That's not what we did, or what you did, is not how the rules is how it's supposed to be operated. You might have input from behind a back door with somebody you called, but the public was left out. This is the People's House, where everybody gets a voice. We represent the people. Not some group, but all the people of the state of Minnesota. You should be ashamed. The last couple conference committees I've been on, we've at least had a side-by-side. This conference committee didn't even have a side-by-side. First meeting, they adopted the agreement. Representative Moller didn't even have a chance to even know what was in the Senate bill until it was after it was adopted. If this is how we're going to operate, why is the minority even here? We're a constitutional republic with laws, a constitution, laws, and rules. They're there to make sure that the minority has a voice. But what has been going on lately is nothing but mob rule and anarchy. Let's do this, send this back to conference committee, do it right, and have an honest conversation about this bill on the House floor. Members, vote for the motion not to adopt.
Further discussion to the motion to refuse to adopt. Representative Niska.
Thank you, Madam Speaker and members. We've heard a lot of concerns about the process, and I won't reiterate that. I think we should send it back to have a real conference committee process. Thank you.
The clerk will take the roll. Members, please vote. The Chief Clerk will call the names of the members voting remotely.
Carol.
Carol, no.
Carol, no.
The Clerk will close the roll. There being 58 yeas and 70 nays, the motion does not prevail. Back to the underlying motion to adopt report of the conference committee. I recognize the member from Anoka, Representative Scott.
Thank you, Madam Speaker. Members, this isn't a really horrible bill. There are some good provisions in it. And I do appreciate the chairs reaching out to me yesterday to run through the bill. And unfortunately, it wasn't on my schedule. And I had a couple of amendments up on a bill that was on the floor, so I couldn't really participate. But the issue there was, as I walked into this room, and everything was already decided and already in concurrence bill form. So the process was less than transparent, and I look at, again, even though it's not a large amount of money compared to what was spent last year, it's still spending more money. And I feel like we needed to have prioritized, especially in these two areas of public safety and judiciary, which are really total functions of what our state government should be doing here. I just feel like it was a missed opportunity last year and misplaced priorities. So sort of a protest vote today, and I'm going to be voting no.
Further discussion. Representative Novotny.
Thank you, Madam Speaker, and I agree with Representative Scott. This is not a terrible bill, and it's not even a kind of a bad bill. There are several things in this bill that we agree with, several things that we support. The funding, although not enough for the victims advocates, the correctional officer funding, we agree with that. This bill does not have anywhere near the anti-public safety provisions we've had in past omnibus bills, so I'm really thankful. I have recommended to the caucus a yes vote. I will be taking a protest no vote, just because of some of the issues. And I'm not going to revisit the process things. That's been covered, so I will move on to that. But there was no public testimony. It got rushed through. We don't need to beat that horse anymore. But why am I no? Well, I've had plenty of time driving back and forth to the multiple promised last meetings of Ways and Means, and I've had time to think about the language and some of the testimony in the bill and why it's a burr under my blanket. And I've come to the conclusion that it's a burr under my blanket because I've been talked into it, okay? Is the language that bad? No, but it's the way it's presented. It's the use of situations that don't apply to what you're stating you're trying to fix. I believe it was Rahm Emanuel who had the don't let a good crisis go to waste theory, and that is the burr under the blanket that just rubs, and why I am going to cast a no vote in protest for that. I suspect I'll be hearing some statistics again in closing that I've heard many times, and if we want to retry some court cases that were, some of them 5-6 years ago, I don't think this is the place or the time to do that. That seems to be where we always end up. And that's the part where that's where my protest vote comes in. I don't think we should do that here, but we continually do that here. So with that, members, I urge you to vote a green if your conscience guides you that way. I will be a no. Thank you, Madam Speaker.
I recognize the member from Washington, Representative Weens.
Madam Speaker, I rise in support of this bill, 5216, for the VRJA reporting. I really appreciate the collaboration with Representative Feist on her revolutionary Veterans Restorative Justice Act in the past. It's helping a lot of veterans. Also, thank you, Chair Moller and Lead Novotny, for giving a hearing and letting it pass through and work through the committee. This is one of those things where you get to serve with people, lead people, and things happen. Of course, things happen in life, but in service, in combat, things break, people break. This bill, the VRJA and the reporting, really is a gap filler for those that have a service-connected issue. Usually it's connected to substance abuse or mental health that may have been caused by a mild traumatic brain injury, military sexual trauma, or post-traumatic stress. And where we can help them, and it's nonviolent, those that have the service connection that's nonviolent, where we can assist them through the process. It's a gap filler. We have the Veterans Treatment Court in quite a few counties, but I don't think enough, and this is where the VRJA fills that gap. And I just want to make certain we know how well we're doing. I think we treated about 64 people last year with the VRJA, and we'll have many more. Again, I got to serve, I got to lead with those service members in some of the most inhospitable and challenging environments that are now veterans that are using this process, and those that are yet to still use them. And they've just gotten sideways with the law, and they need a little bit of help, and this is where we can help. So, Charlie, Mike, that's Continue Mission. Thank you. I encourage a green vote for 5216. Let's do this for the veterans. Thank you.
I recognize the member from Hennepin, Representative Nadeau.
Thank you, Madam Speaker and members. I was one of the few people that voted for this on this side coming out of the committee, and I'm glad to see that it came back a little bit better. I'm truly, and I will continue to support this because I support the way that you've reached across the aisle to work with members on this side to try to craft a bill that we can support. And I've been super critical to some other bills where I felt like that we were shut out of the process, and I feel that it's only right to stand up and acknowledge when I feel that has changed. I don't agree with everything in this bill. I think it's funny how this Anoka County training, the Criminal Justice Center, keeps popping its head up, Representative Stephenson. And but I'm glad to see that we're finally going to get this thing through. Even though I don't completely agree with it, but I'm glad to see that there is some bipartisan support and acknowledgement, and I appreciate the chairs, both chairs, doing that. So I'm a green vote, Madam Chair, Madam Speaker, and thank you.
I recognize the member from Isanti, Representative Johnson.
Members, Madam Speaker, members, unfortunately, I'm going to be no on this. There's some things in here that concern me. There's a lot of good things. I want to thank Representative Becker-Finn for having a actually very good judiciary bill when it came out of committee and left the floor. Representative Moller, overall your bill wasn't bad. There was a few things that I had problems with and I couldn't support it. But on the first time it came out, I missed something that I have a lot of problems with that's still in the bill. So, that would be the excited delirium. I've actually, in my career in law enforcement, dealt with it. I'm just doing some research, some more research on it. The medical field still doesn't know how to handle it. Law enforcement gets training from them on what best practices are regularly. And it changes from time to time. They find out new things. For those of you who don't know what excited delirium is, it's usually brought on by narcotics, a lot of times cocaine, fentanyl, opiates, from overdoses. It causes extreme body heat, so you'll see people running around with no clothes on, trying to cool off. Find them deceased in a bathroom wrapped in wet towels, trying to cool off. They die from two things. Either they quit breathing or their heart stops. In my career in law enforcement, I dealt with it twice. Fortunately, we caught it early enough and had the ambulance on its way, and both survived. About 2/3 of people with excited delirium do not survive. They don't make it to the hospital. Either die in the field, in the ambulance, or in the back of the squad car being rushed to the hospital. And in this bill, it pretty much says you can't do training on it. You don't get reimbursed. This is a serious medical issue that we're not going to train our law enforcement officers on how to deal with it. This is the wrong thing to do. It's very concerning. Especially in greater Minnesota, where you might have a half-hour wait for an ambulance on a good day. What's an officer supposed to do? Is that the right thing to do to the citizens of Minnesota that has a problem? Or should we allow our officers to get trained on the best practices that are available at the time? With this provision, it makes it very difficult to vote for it. This needs to, we need to vote red on adoption, send it back, and just tweak this a little bit so they can have the training of the best practices. This is something that the medical field has been working on for over a century. But they don't know a lot about it because most people die before they get to the hospital. But they're learning more and more every day. But when you don't have a hospital within a short distance, you have to wait 45 minutes, half hour for an ambulance. There is no hope for those. But law enforcement officers are the first ones there. They're dealing with it. Give them an opportunity to be trained in best practices for the situation. Members, with this in there, those that have an addiction problem, with this in here, it could be a death sentence for them. Please vote no on the adoption.
There being no further discussion, all those in favor of the motion to adopt the conference committee report on House File 5216 say aye. Those opposed say nay. The motion prevails. The clerk will give the bill its third reading as amended by conference.
Third reading, House File number 5216, as amended by conference.
I recognize the member from Chisago, Representative New Brindley.
Thank you, Madam Speaker. And I just want to say thank you to Representative Becker-Finn. I also never thought thought that I would spend the number of hours I spent learning about and discussing the sale of human remains and the exceptions that we needed for donation to make sure that we are protecting our interests. So I just really want to thank you for digging into that after it left this body and making the choice to include all human remains and not just calcified human remains. Thank you for that.
Further discussion. I recognize the member from Carver, Representative Nash.
Thank you, Madam Speaker. Members, pro tip, get rest on the night before you talk about an emotional bill. I did not, so here we go. Buckle up. I'm voting green. And I'm voting green for every kid that hid from the beatings of their abuser, for every person who has survived the beatings of their abuser, to every person who has gone through the majority of their life trying to figure out what the hell that all meant. Because it does make sense. And I'm voting green for every survivor that has broken the cycle. It can be done. You do not have to be the thing that abused you. You don't have to go down that road. You can be a strong example to the people who are in your life, to the people who you love. And I'm grateful, Chair Moller, Chair Pinto, who is somewhere else, Chair Becker-Finn, to all of my friends here who have propped me up along the way. I'm going to say this too. To every person that has been abused, don't wait till you're 55 to start jumping into the deep end of the pool. I've lost hours of sleep suffering through this. It does get better. So before I completely fall apart, I'm going to ask you to do one thing. I've asked a number of friends to do this, but I'm going to ask everybody here. If your dad is still in your life, and your dad is a good guy, a good man, call him and say thank you, because I can't make that call. Vote green.
I recognize the member from Moller, Representative Moller.
Thank you, Madam Speaker. And as we all take a moment to wipe the tears from our eyes, I voted red for the process. I'm voting green for the bill, because the bill is good. The bill is going to save lives. The bill is going to give resources to people who are like me, like Representative Nash, like the many other who are in this chamber. And while I was not the victim of physical abuse, I was the victim of sexual abuse. There's going to be future me's that get help because of this bill. There's going to be people who are going to be better because of the green vote we take today. And I will proudly stand with Representative Moller and Representative Becker-Finn with that. There are days in this chamber where we tear each other apart And there are days where we can lock arms and do what's right. This is one of those days, members. Join me in voting green.
I recognize the member from Ramsey, Representative Becker Finn.
Thank you, Madam Speaker. So one of the comments earlier was referred to our committee process as mob rule and anarchy, and you can accuse Representative Moller and I of a lot of things, I suppose, but if you've actually ever been in our committees, that is not a very good description of how we run our committees and how we do this work. I do want to say thank you to Chair Moller. This will be our last bill together, and it really has been incredible to mentor and become good friends with you, and for us to be able to chair these two committees together throughout the last couple of years has been just a really incredible process, and I think is how this work is supposed to get done and how we're supposed to do it together. I also want to say thank you to Representative Nash. We have been working on issues around mandated reporting for several years, and there's another person in the gallery who is also really important to that work. And I think thank you too. You know, we talk a lot about kids and protecting kids, and I know we don't all have the same point of view on a lot of things, but the reality is that unfortunately, more kids are in danger in their own homes and in their own communities than some of the other monsters that we dream up when we talk on this floor. The reality is the things that we know have happened to people in this room, and when we know better, we can do better together. And I think folks probably don't realize, you know, it doesn't seem like Representative Nash and I would be the kind of people who would get along, but we do, and it's not just on liquor liquor bills, but you know, I think I think of the work we've done together on these issues over the years as one of the examples of how we all can do this work well, regardless of whether we're in the majority or the minority. And so I do want to thank you for that, even if we don't agree on other things. So yeah, this is a good bill, and I think Representative Mueller, folks probably know I'm a rules person. There are things about the process that weren't my favorite either, but again, you know, I don't control the Senate as much as many of us wish that we did, regardless of what party the senators come from. So it's a good bill, and I think the members from both sides of the aisle who contributed, I do think they're really important provisions. And again, this is also just a really important bill because we're funding our third branch of government in the courts as well. And so I think that money going into that system is money well spent. So just thank you again to our staff as well, and I hope folks can support the bill. Thank you.
I recognize the member from Sherburne, Representative Novotny.
Thank you, Madam Speaker. And I'm reminded of a quote that President Reagan had, and he said, if we are in agreement on 80% of things, we are not 20% enemies. Members, I recommend a green vote. Thank you.
I recognize the author of the motion, Representative Moller.
Thank you, Madam Speaker, and thank you so much for your kind words on the House floor. Really appreciate it, and I'm really moved by the remarks that were made today and the work that we were able to do together. I'm also really emotional because I am going to miss Chair Becker Finn. She really has been an incredible mentor to me, a leader, and a dear friend, and so thank you. Representative Nash, I appreciate you, and I appreciate you sharing your story to make a difference for the lives of others. And to you too, Representative Mueller. You know, in the Public Safety Committee, we hear from a lot of people who've experienced horrific and terrible things. It can be a very difficult committee at times, and I'm always amazed by the people who come to our committee and share their most deeply personal and horrific moments in their lives in order to make something better for the person behind them. And while we may disagree on many different policy things, I know that at the end of the day, we all want public safety in Minnesota. We all want that. And I really try to come at this at a place from assuming good intentions from everybody across the aisle, from my colleagues. And I truly do believe that we all share that goal. And I'm just really excited to hear that so many of you are going to vote yes on this bill. It's been an honor to be chair of this committee, and I'm really looking forward to that board lighting up. Thank you.
The clerk will take the roll. The chief clerk will call the names of the members voting remotely.
Carol.
Carol, aye.
Carol, aye.
The clerk will close the roll. There being 107 yeas and 19 nays, the bill is repassed as amended by conference and is titled agreed to. Messages from the Senate.
Message from the Senate. Madam Speaker, I hereby announce that the Senate has concurred in and adopted the report of the Conference Committee on Senate File Number 3492, an act relating to housing. The message is signed Thomas S. Bodern, Secretary of the Senate. Conference Committee report on Senate File Number 3492. The report is addressed to the Honorable Bobby Joe Champion, President of the Senate, the Honorable Melissa Hortman, Speaker of the House. We, the undersigned conferees for Senate File Number 3492, report that we've agreed upon the items in dispute and recommend as follows. The report is signed by 2 of the 3 members on the part of the Senate and 2 of the 3 members on the part of the House. Agbaje moves that the report of the Conference Committee on Senate File Number 3492 be adopted and that the bill be repassed as amended by the Conference Committee.
I recognize the author, Representative Agbaje, who will explain the report.
Thank you, Madam Speaker. This is the landlord-tenant conference report. Both the House and the Senate did work together to come to an agreement, and even within our conference committee, we had a number of amendments that we were taking up. Unfortunately, we did have to remove significant portions of the bill that were really important to renters' rights, particularly the prohibition on the source of income discrimination and the repair and deduct provision. Both provisions would have been necessary to ensure that tenants can find homes or stay in a well-maintained one. And we also dropped new remedies and penalties for certain policy provisions. But regardless of the things that we had to lose in this conference report, it does still remain a good bill that gives tenants the right to organize. It protects survivors of domestic violence from retaliation and eviction. It allows people to call for mental health help without the fear of eviction. It creates a streamlined judicial process for evictions and a duty to mitigate and an expansion of the covenants of habitability to common areas in living spaces. We also continue to work to limit the damage of an eviction filing on a person by requiring that tenant screening agencies provide the most up-to-date information, and also saying that landlords cannot use filing as the only reason to deny an application for housing. Finally, what we worked on is we worked on the enactment dates. So similar to the landlord-tenant policy bill that we passed last year, the enactment date for this one will be January 1, 2025, except for the provisions relating to domestic violence survivors, which will be 30 days after enactment. I just want to say thank you to the conference committee members, the conferees, both Representative Howard and Representative Myers. I think we had a really engaging discussion with the Senate on different pieces, and I just also appreciate the efforts going into ensuring that more tenants across the state of Minnesota can live in safe, dignified places, and we will continue to do that work. So I urge members to adopt the conference report. Thank you.
Discussion to the motion. I recognize the member from Hennepin, Representative Myers.
Thank you, Madam Speaker. Thank you, Chair Howard, and thank you, Chair Agbaje. I think the process within the committee was good. What I appreciated is that we did have a couple testifiers come in. They, shared their thoughts, and I could tell that you had worked with the stakeholders. We had emailed each other back and forth during that time. So I do want to thank you for that. There were some reasonable changes made to it. But what I would say is that I would ask members to vote no. I think there was an opportunity to provide a little bit more of that balance for the landlord tenants. But overall, the process was good.
Further discussion? There being no further discussion, all those in favor of the motion to adopt the Conference Committee report on Senate File 3492 say aye. Those opposed say nay. The motion prevails. The clerk will give the bill its third reading as amended by conference.
Third reading, Senate File number 3492, as amended by conference.
Third reading is amended by conference. Any further discussion? I recognize the member from Isanti, Representative Johnson.
Madam Speaker, members, overall, the process was good. But we still have issues with this bill. I'm going to deal with the housing portion. In the housing portion of the bill,
Until the next one.
Some things changed a little bit. We did get, actually, the housing part did get better. But there's still some concerns. One of the concerns that I have is the denial based on pending eviction notices. Now, if eviction notice for non-payment of rent, that's one thing. But this is denial on any pending eviction notice. It could be eviction notice for sales of narcotics around little kids. Could be eviction notice due to serious safety concerns of the person. Those are things a property provider, a housing provider needs to know for the safety of the other tenants. Because guess what? The housing provider can actually get sued if something happens. But we're not allowing that to have that information. Now we also changed it a little bit, and I understand it. If you're calling for help because of a mental crisis and you're the tenant or somebody that lives with that tenant, family member, again, you should not be evicted because of that. So, but if you're a tenant and you're calling in your neighbor constantly because of mental health crisis and refusing to get the help, again, it's a safety issue for the rest of the tenants. But the way this bill is written, nothing can be done about that. So there again, it's back to liability on the property, on the housing provider. Then we have another issue with the debt ceiling. I have concerns there. Members, Overall, this isn't bad, but the biggest concern another big concern I have is this bill is doing nothing to lower the cost of housing. In the labor portion, they have a provision that is actually going to increase the cost of rental units for subsidized housing. Now, earlier this year, former member and now mayor Dan Fabian was here talking about issues in greater Minnesota, being able to use the funds to get workforce housing and other types of housing. The way the grants were set up originally, the state provided 25% of the cost. And it turns out that because of prevailing wage issues and other issues, that didn't cover the cost. So it didn't cover what the costs were to keep the cost to the local community down. It ended up that the cost of the building to build it,
Madam Speaker.
was much more.
Representative Agbaje, for what purpose do you rise?
Thank you, Madam Speaker. I just want to do a point of parliamentary inquiry. What bill we're talking about and the subject of the bill?
We are talking about Senate File 3492, which is the Landlord Conference Committee report. Representative Agbaje.
Thank you. I just wanted to make sure that's clear. This is just the landlord-tenant policy bill. This has no fiscal impacts in the housing fiscal bill, which is combined with the labor and transportation bill, which we are not taking up right now. Thank you.
Representative Johnson.
Madam Speaker, members, it was a late last night, and I got my housing bills mixed up. I apologize. Thank you, Representative. So I will, as I said earlier, this bill did get better than when it left the House.
Further discussion. I recognize the member from Hennepin, Representative Howard.
Thank you, Madam Speaker, and thank you, members. Members, we've had an incredible 2 years in this House of Representatives in our work and our advocacy to update our renter landlord laws that haven't been updated in decades. And I want to first start with a thank you to our Vice Chair, Esther Agbaje, who has done amazing work to guide and lead this body to make really transformative changes that will make a difference for Minnesotans for years and decades to come. And overall, I think what you've seen from this legislature these last 2 years is a values proposition shift where we are making sure that in this body, we are listening and taking seriously to the concerns of Minnesota renters. There are hundreds and thousands of renters all across the state of Minnesota. More than half of those renters are cost burdened, paying more than 30% of their income in rent. We know that hundreds of thousands are paying more than 50% of their income in rent, and are one bad break away from an eviction, and are one bad break away from a power dynamic that threatens their housing stability now and for decades to come. And already the changes we made last year, including our pre-eviction notice, are working. They're preventing housing crises before they start, preventing evictions, and helping families stay stable in their homes. And we know that if a family faces a housing crisis, that can be trauma for a family that is transformative for that family for decades to come. And so this bill and this work of this legislature will be life-changing for Minnesota families all across the state. And we need to continue to make this body and this place a state where we listen to all people, including renters. That has happened these last 2 years. And I want to again share my thanks to the Housing Committee members, to renters all across the state that have showed up at the Capitol to speak to us and help make these changes, and again to Vice Chair Agbaje for leading these efforts. Thank you.
I recognize the member from Hennepin, Representative Myers.
Thank you, Madam Speaker. I do want to, say thanks again. There was an amendment I offered that gave a little bit more consistency, which was accepted, and that was in regards to the effective date, and that was something that everybody on the conference committee agreed with. I do want to point out, though, there were some provisions that were really big that were not included, and I know your side of the aisle really wanted those, and I understand the reasoning for that. So I know that probably this isn't the bill that you were looking for specifically. But I do want to say that the process was good. There was a little bit of that missing balance of that, striking that balance for the landlords and tenants. Additionally, the penalty fees, some of those were removed, so that was a benefit as well. But I would just remind this body to, vote no on this particular bill.
I recognize the author of the motion, Representative Agbaje.
Thank you, Madam Speaker. Thank you, members. I do want to thank staff who helped with this. I think it's really important that we were able, both in last session and this session, to ensure that landlord-tenant policy had its own vehicle and was able to move and show the people of Minnesota that we really care about renters. Additionally, I do think that this is a good bill. It really puts us on the track of ensuring that more people have more of a voice in the living spaces where they are. At the end of the day, tenants deserve the same as homeowners. It is their home as well, too. So I encourage this body to vote yes, and thank you so much again to all the conferees. It was a great conference committee, and I had the pleasure of working with all of you. Thank you so much.
The clerk will take the roll. The chief clerk will call the names of the members voting remotely.
Carol.
There you go.
Carol, aye.
Carol, I.
The clerk will close the roll. There being 69 yeas and 60 nays, the bill is repassed as amended by conference and is titled agreed to.